You get promoted to a new job. Huh? Right, we're on record in case number CR20150116, State of Ohio versus Kevin Gaffin. Present for the state is a Special Prosecuting Attorney Scott O'Reilly and Assistant Darren Miller. Present for the defendant is Aaron Haslam. And are you Kevin Gaffin?
Yes.
All right. There's some preliminary matters. We're assembled. The jury's not yet present. We're here for trial this morning. There were some preliminary matters that need to be put on the record. First of all, I did file this morning the ruling on the motion to dismiss, overruling that, and also limiting the polygraph testimony to be the written reports and not the and the polygraphers would not be testifying. That was in accordance with the ruling I made last week by a telephone conference. Each of the attorneys received that ruling.
Yes, Your Honor.
Yes, Your Honor.
All right.
Thank you.
Now, the second matter was there was a request or a motion for a jury view. I've had a meeting with counsel in chambers, and my understanding that's going to be withdrawn.
That's correct, Judge.
Okay. The state had filed a motion to amend the indictment and then vacated that, filed a motion to amend the bill of particulars to correct a date. And I did discuss that again in chambers with counsel and just indicated that my belief is under Rule 7 that the bill of particulars can be amended at any time without leave of court, so I'm permitting that amendment. And the state or the defense is in agreement or doesn't object to that being the law?
Your Honor.
All right. All right, and then the final matter, and I think we did cover this last week, but just to be safe, Mr. Haslam wished to have any plea offer placed on the record, and the defendant's response to that, in my understanding, there is not a plea offer. Is that correct?
Yeah, Judge, what I can indicate is prior counsel for the state had made an offer of count 7 with a recommended 6-year prison term. We wanted to indicate on that on the record that that is withdrawn by the state at this point in time, and there is no plea offer at this point.
Okay. All right. So, are there any other preliminary matters need to be discussed before the jury is seated? Or I should say the voir dire panel is seated.
Nothing from the state, Your Honor.
All right. All right, then I believe we have a final list. Did each of you get that?
Yes, Your Honor.
All right, and it's my understanding this is the number, these are the persons who are actually present, and so the bailiff will be seating them here momentarily in the chronological order. And my understanding, you're going to start back in the right-hand side and go 1 across. Is that correct?
Correct.
All right. So I'll go ahead and recess, and then when that's completed, then I'll be back in, and we'll get started. Oh, and by the way, one other thing. There is the renewal of my blanket assignment from April 1 through September 1.
Your Honor.
That Mrs. has been filed, so thank you.
Judge, would you have any objection if we swing around since the jurors...
Absolutely not. That's usually the practice, yes. And are there microphones, or, I don't know, is there, you're going to be able to pick up the responses okay, or you have a remote mic? Okay, thank you.
Rocky A. Koss presiding.
Thank you. Be seated, please. All right, good morning, ladies and gentlemen. I'm Judge Rocky Koss from Common Pleas Court in Highland County. I've been assigned to hear this case of State versus Kevin Gaffin. Now, I know you've been told to turn off your cell phones, and that means turn them off, don't leave them on mute or silent, because I've had situations where even though that was done, the phones went off. And I have a strict rule that anybody that has a cell phone goes off in court during record proceedings gets fined $25. I fine myself, and I'll certainly fine anyone else, so just so you know. All right, this is a criminal case, and the defendant is charged with 3 counts of rape, 3 counts of sexual battery, and felonious assault. And he'll be represented by counsel here today, as will the state. And so at this time, I'm going to ask each of the parties to identify themselves and counsel, and start with the State of Ohio. Mr. O'Reilly.
Thank you, Your Honor. Good morning, ladies and gentlemen of the jury. My name is Darren Miller. Nice to meet you.
My name is Scott O'Reilly.
Aaron Haslam, I'm counsel for Kevin Gaffin. This is Kevin Gaffin.
Thank you. Now, ladies and gentlemen, the fact that the defendant has been indicted is not the evidence of a crime. And the fact that there has been an indictment returned cannot be considered by the jury in any way. An indictment is simply the means by which the state brings a charge against a defendant so that he or she knows what they are charged with and what they must defend against in this case, or in any case. Now, the defendant, as he sits here today, is presumed innocent under the Constitution until he's proven guilty by proof beyond a reasonable doubt by the state of Ohio of an offense. And so, all of you are just like him. Each of you who come into this room are presumed innocent of any crime until you've been proven guilty, and that is equally true of the defendant. And so there's not to be any inference made that simply because he's here that he must have done something, because that is absolutely not the case. Anyone who is charged with a crime has the right to require the state to prove their guilt by proof beyond a reasonable doubt, and our system and our Constitution says that you must presume that he's innocent until that should occur. Now, I'm aware that all of you have appeared today not as volunteers because you were drafted, and it's not in your normal schedule, and all of us appreciate that. But service on the juries is an important part of our American judicial system. I think it's very appropriate today as Flag Day, recognition of the emblem of our country, and we all enjoy the right under the Constitution to have a trial by jury. And we're very fortunate in that regard because there are many countries, in fact most countries in the world, in which citizens do not have the right to have a trial by jury. And so I would hope that each of you would look at this call to service not as an obligation or an annoyance, even though it's disrupting your normal schedule, but as a duty of citizenship that you owe because you have been lucky enough to be a citizen of the best country in the world, in my opinion, and the best system of justice. Now, we're going to do everything we can to keep this case moving. At this point, it's anticipated that it will last until Thursday or perhaps Friday, but we will be we'll be starting each morning after today at 8:30, and we'll go to around 4:30 or 5, and that's to make sure that we have full days and I don't take real long recesses once we get a jury seated. Now, in terms of scheduling for comfort breaks, my policy is to try to break every 75 to 90 minutes, hour, 15 minutes to hour and a half. At age 65, I require comfort breaks just like the rest of you. So if I'm uncomfortable, then you're probably uncomfortable. And so we will do that to try to give everybody the chance to stretch their legs, get a drink, use the facilities, and that type of thing. Now, under the law of Ohio, the judge is the one who gives the instructions of law, and all persons that are participating in the proceedings are required to follow that. And so, as prospective jurors, that applies to you. And so, what I want to tell you, several things, is that if we do take recess before we have completed the jury selection, and you leave the room, that during those breaks, you're not to talk with anyone about this case or anything that's been brought up while the court has been in session. You're not permitted anyone to discuss it in your presence. You're not permitted to talk with any of the participants that have been identified here in the case, and again, with anyone for that matter about the case, but particularly not to have conversation with counsel or the defendant or any witnesses as once the case starts. The state and the defendant are each entitled to have jurors who approach this case with an open mind and agree to keep their minds open until a verdict has been returned. Now, jurors must be as free as humanly possible from any bias, prejudice, or sympathy, and are not to be influenced by any preconceived ideas, either as to the facts or as to the law. Now, all of you are undoubtedly qualified to serve as a juror. However, there may be something that would disqualify you in this particular case, and that is one of the reasons why we conduct the voir dire examination, to question prospective jurors for that purpose. Now, although everyone has some predetermined ideas, I mean, we live in a country with free speech, and everyone's allowed to speak their mind fully and completely, and based on what I read on the internet, probably too much. But in any event, you do have that right. However, when you come into the courtroom as a prospective juror, the American jury system is based on the principle that you, if seated, will decide this case with an open mind based upon the law and the evidence. And for this reason, we ask that you be totally candid and open about personal feelings when answering questions during this process. There's nothing wrong with openly acknowledging you may have a bias or some particular information or situation that might prevent you from being a juror in this case. That type of honesty is what allows our system to work effectively and properly. Now, this is called, we're coming to the point of called voir dire examination, and that is where you will be asked questions under oath, just like a witness, so to speak. And for that reason, we will have the deputy clerk administer an oath or affirmation to you in a moment. And I will just explain to you that voir dire basically is a French term that made its way into our American system. I really don't know the historical origin of it, but it's a French idiom that means to speak the truth. And that's why you're being placed under oath, and that's why it reflects that, and that's what it's called in our system. So at this time, I'll ask the deputy clerk to administer the oath or affirmation to the prospective jurors.
Does anybody wish to be affirmed rather than sworn? Okay, I will ask those of you who want to be sworn to stand up, please, and raise your right hand. You do solemnly swear that your answers to all questions addressed to you by this court and counsel touching your qualifications as jurors, and the case now pending before this court, shall be the truth, the whole truth, and nothing but the truth. As this you do, you shall answer unto God. Please answer for saying right to you.
I do.
Sorry. And those who wish to be affirmed may please stand. You do solemnly affirm that your answers to all questions addressed to you by this court and counsel touching your qualifications as jurors, and the case now pending before this court, shall be the truth, the whole truth, and nothing but the truth, as this you do under the pains and penalties of perjury. All right, thank you.
Your Honor, may we approach?
Yes.
Gentleman in the black t-shirt. Yeah. Gentleman who did not swear or affirm. He's in a black t-shirt. He was standing to the left of the gentleman in the sport coat who stood up for the affirmation.
Is he here in the court?
Front
Inside the
row.
bar and in the back?
Front row closest to you. The gentleman stood for affirmations to the left in the black t-shirt with a hat, holding a hat in his lap.
I can't see that. He's
Right between
behind
Scott and Darren.
Okay. Let me over here in the first row, the big guy.
No, here, right between them, right now. The black t-shirt.
Okay. All right. We'll just note that later. All right. Now, ladies and gentlemen, there are certain questions that I'm required to ask of you to ensure that all of you are qualified under the law to be questioned by about service. So I'll ask those questions at this time. In order to serve as a juror in this case, it's necessary that you be a legal resident of Adams County today. I don't know when Adams County draws their jurors specifically. We generally draw them in October. But are any of you today no longer residents of Adams County? All right, no one? The indictment in this case was returned in July of 2015, and today is June the 14th, 2016. So I ask if any of you prospective jurors were members of the grand jury that considered this case. None? Now, are any of the prospective jurors or your spouses a party in a case in which any of the attorneys that are present have introduced themselves today are involved, whether representing you or your spouse or another party in that proceeding? None, all right? Have any of you been subpoenaed to be a witness in this case? None. Now, do any of the prospective jurors or your spouses have any type of legal action pending between you and the state of Ohio? That could be a criminal case, a traffic case, a civil case, such as eminent domain, a licensing case, or some other matter with an administrative agency. Right in the back row on the left. What's your name, ma'am? Catherine Jones. Okay. And what type of matter is that? Pardon me? A tax lien. All right. Is there anything active on that right now in the courts? Has it just been filed? It's just filed? Okay. All right. Thank you. Anyone else? All right. In the second row. And your name, sir?
Tom Reed.
Tom Reed.
Yeah.
Okay?
I just had a gentleman break into my business a few weeks ago, and I'm due in court.
Okay, but you're not, it's not against you. You are a witness in that matter.
No.
Okay, thank you. Anyone else? Okay, thank you. All right, now, this next question, I'll ask it the way it's set forth in the rule, and then I'll explain it to you, so don't panic. Are any of you related by consanguinity or affinity within the 5th degree to the defendant, or any person alleged to be injured in this case, or anyone connected with either party? Okay, consanguinity means by blood. Affinity means by marriage, and I really don't know why it's written that way, but that's what it means. So what the question is, to your knowledge, are any of the prospective jurors related either by blood or marriage within the 5th degree? And I don't know who my 5th cousins are. Maybe some of you are 5th cousins. So far removed, I have no idea. But any relationship at all that you're aware of by blood or marriage to the defendant, any person who was alleged to be injured in this matter, or any of the attorneys? All right, none.
You know, can we approach that?
Sure.
Judge,
With the white noise. Okay.
Judge, I don't know if they know who the alleged victim is at this point,
Well,
Ryan.
you
I'm
can
okay.
bring it up.
Okay, I just
want
want
here, and we'll deal with that.
Thank you.
Okay. Now, the next question, are any of you an employee, or your spouse, or any member of your family, which would be a child, parent, grandparent, are any of those persons or you an employer or employee of any of the persons I just mentioned? That would be the defendant, the state, or any of the attorneys that are involved. None. All right. Well, I'm sorry. I didn't see you, sir. What is your name, first of all?
Edward Young.
All right.
My sister-in-law, the young man that was supposedly assaulted or whatever, is her nephew.
Okay. So your sister-in-law is the aunt of the alleged victim.
Yes, sir.
All right. Thank you. Anyone else? In the back row, your name, sir? I'm sorry, Roger what?
Fetters,
Okay.
did you say the employee of the state?
An employee of any of the persons that are involved in this case would be the county or the prosecutor, prosecutor's office, these are special prosecutors, anyone else? All right, none. Okay. And then in the back row, your name, sir?
My name's Michael Lucas.
Okay.
The defendant was at one time married to my cousin.
Okay. All right. Anyone? Okay, front row, ma'am. Your name?
I'm Emily Hughes.
I'm sorry.
I'm Emily Hughes,
Emily Hughes. Okay.
and the defendant was married to my aunt.
Okay. Anyone else? Yes, ma'am. Your name?
Jade Osmond. Jade Osmond.
Jade Osmond. Is that A-U-S or O-S?
O.S.
Okay.
I'm an employee of Adams County Children's Services.
Okay.
I'm a caseworker, which was involved in the initial investigation of this case.
All right. Counsel, is there any objection to excusing her? I don't see any reason to keep her around. All right, you're excused then. Thank you. All right, anyone else? All right, for those of you who had a comment when you were questioned, I'll permit the attorneys to ask further questions about that. All right, any other persons that would have a response to that? All right, then the final question that's required by rule is that are there any of you, the prospective jurors, for whom English is not your native language? In other words, were you born in a country in which English is not the official or predominant language? None. All right. Well, that completes the requirements the court's required to ask, and subject to questions of those of you who had response to the next to last question, you're all qualified to be considered to be jurors in this case. Now, I've had you seated in a specific order, and the purpose for that is I have a system where I do a group voir dire instead of just the first 12 and then keep people moving in and out. I find that, at least for me, and the trials that I've handled the last almost 8 years, that it moves more effectively, and we usually will get a jury more quickly. Now, the people in the first 2 rows, I believe there are 35 total, they will be questioned first. And so those of you over here are not going to be questioned directly. So if they ask a question that calls for a response from any members of the group like I just did, you're not required to raise your hands, because at this point my hope is we'll be able to get a jury from the first 35. Now, if that does not prove to be true, then we will move into the next row, and I'm not sure exactly what order you're in, where 36 is, but we'll go to that juror on the list and then move forward that way. But it's not to mean that you're not important. You're important because it may be that you will end up being considered for the panel. We just don't know. But generally, in my experience, about 90% of the time, I'm able to get a jury from the first. We actually do 24 in my county. Here we're doing 35. And so generally, we're able to get a jury from that. And so therefore, we save a lot of time by not asking questions of people who are not likely to be seated. And that helps move things along. All right, so with that, I'm going to permit the attorneys to ask you questions. Now, I want to tell you that the process of voir dire will be somewhat probing and may ask questions of you that you've never been asked before, and maybe you feel that uncomfortable, or that attorneys of the court are prying into your personal affairs. And in a sense, that is what we're doing, but not for the purpose of causing you discomfort or annoyance or embarrassment, but simply to ask questions that might have some bearing on whether you can be a juror in this particular case. So please don't take it that way. Now, you'll probably ask about whether you've read or heard anything about this case. And I'll tell you that as a juror, you are to decide the case based upon the evidence in the law, free of any information that you may have obtained outside the courtroom. So if you've read or heard anything about this case, if you're asked that question, don't specifically state what that is until the court determines that you should. And maybe there may be some occasions where we'll have a period of talking with you alone outside the presence of the other jurors. And we do that simply because, if you say something that you may be the only person that read or heard that and no one else had, now that complicates matters, and then they have to be asked questions about that. The simple fact that you have read or heard something about the case is in and of itself reason for you to be excused. The question will be whether or not you'll be able to set aside that and determine the case based on the evidence in the law, free of that influence. If at any time, again, there's any kind of topic that you feel you wish to keep the information as private as possible, just let me know, and again, we can take a break and talk with you outside the presence of the other jurors. All right, with that then, I'll turn this over to the state. Mr. Riley?
Thank you, Your Honor. Do you have a preference where you want me to stand?
No, you can go anywhere. I'll let you turn your back to me on this part of the case.
Can I pull the podium over?
Yes,
Your Honor? Is that okay?
feel free to.
It's attached. Yep. Where's your sound?
How about this? I'm going to stand right here. Apologize for turning my back to the judge. Thanks for the setup. Good morning, ladies and gentlemen of the jury. Again, my name is Darren Miller, and I, along with Scott O'Reilly, represent the state of Ohio in this case. It is our honor and our privilege to represent the state of Ohio in this case. This is a very important week for the state of Ohio. It's certainly a very important week also for defendant Kevin Gaffin. I say that because during the process of this jury selection, there may be some levity, some laughter. That is certainly not to diminish the seriousness of why we're here. So that's the process. Sometimes questions elicit a funny response. But my personality, if I happen to laugh or smile, it certainly doesn't diminish why we're here. It's a very important day, very important week for the state of Ohio. Jury service, I want to thank you all for being here today. It's a sacrifice just being here today. If you're selected, at the end of the case, it's been my experience the jurors are always proud and happy they got the opportunity to serve. And without your service, we cannot have a criminal justice system. I want to list prosecutors from Claremont County. Mr. O'Reilly and I are special prosecutors from Claremont County who are trying this case in Adams County. I want to list all the attorneys that I've worked with in Claremont County to make sure you don't know them or have a conflict with them. First of all, there's Vincent Ferris, who's the elected official. Again, I'm Darren Miller. Laura Barron, Tom Scovanner, Carol Rowe, Katie Terpstra, Nick Horton, Mr. Scott O'Reilly, Matt Wiseman, Ernie Ramos, Joe Palmer, Alan Edwards, Mary Lynn Burke, Jason Fountain, Dottie Smith, Alex Jones, Zach Zipperer, Jenny Nichols, Tom Plessa, and Chris Earhart. You want to know those individuals having anything pending with them. Sir, what's your name in the back?
Tom Rabel. I know Chris Earhart from working in Brown County.
And how do you know him, sir?
I worked in schools in Brown County. There were times where truancy cases filed. Chris Earhart was the prosecutor.
Okay. And Mr. Rabel, that experience with Mr. Earhart, does that give you pause, have to sit on this jury, the fact that you know Mr. Earhart from his work in Brown County, not at all? You can listen to the evidence to be fair and impartial?
Yes, sir.
Okay, and what did you do for the school, sir?
I worked for administrative support in truancy, civil rights stuff, administrative investigations on behalf of the school district for alleged or suspected employee misconduct, things like that.
And what school, the whole, what school?
Brown County Educational
Okay.
Service Center, but I do this in a number of different counties across the state of Ohio.
Very good. Thank you, sir. List of Adams County prosecutors: David Kelly, who's the elected official; Chris Blanton, who's an assistant prosecutor; Michelle Harris, Nikki Whalen, Ken Armstrong, and Barbara Moore. Now, I expect folks may know some of those individuals. That doesn't necessarily disqualify. So who knows those people? Okay. Well, let's do this. Let's start first. Is it Mr. Dean?
Yes, sir.
Mr. Dean, I saw when just at the beginning, I'm not trying to point you out, but you were shaking your head. Is there an issue with you being here today? Is there some reason you don't think you should sit on this jury? Or? Okay. When you say you got
kids to raise.
okay, well, Mr. Dean, you look just for a minute. So you work here in the concrete business, sir?
Yes, sir.
Okay. And is it your belief that being here the next few days would be a financial hardship on you?
Yes, sir.
And can you kind of explain that to me, why that is?
I got rent, rough payment, food, little food.
Yeah, and I understand that, and we all do. But
I mean, I lose a lot of money every day.
you missing out on jobs here today,
Yes, sir.
and you have job scheduled all week. Now, are you a four-person, you have your own business, you work for someone, how's that work? I'm sorry?
Foreman, greasy, help me work.
And you think the fact that you'd be, this financial hardship that you're speaking would cause some problem with you kind of sitting here to the next week and listening to the evidence?
Oh, man, it was stressful.
Now, there were a number of hands that went up, and we'll talk about those issues, but of those hands that went up, does anyone have a close relationship with those individuals I mentioned from the Adams County Prosecutor's Office? And sir, what is your name? And sir, how do you, who's your personal contact and your close relationship? Who's it with? Okay, how do you know Chris Graham?
His family and wife vacation together. Our sons are involved in plays, musicals, the band, and so on together.
So do you vacation with Chris Graham?
Yes.
You consider Chris a close friend? If you sat on this jury and whatever your decision might be, guilty or not guilty, Would you have difficulty discussing that issue with Chris Blanton? Will it make you feel uncomfortable? You think, even though you have that close relationship and you vacation with his family, you think you can sit here and reach a fair decision based on the evidence that's presented?
I'm a school teacher, I try to look at both sides.
Thank you. Any other close relationships? Yes, ma'am, what's your name?
Rebecca Parker.
Bear with me 1 second, please.
Number 440.
Thank you. Ms. Kirker, with whom do you have a close relationship?
Chris Blanton.
And what's that relationship?
He is my husband's first cousin.
Husband's first cousin? How often do you see Chris?
Probably
Once a month? Does that relationship give you some pause about sitting on a criminal jury trial? Think you could be fair to the state of Ohio and fair to the defendant in this case, even though you have that relationship, to see Chris once a month at least? Who else? All right. We have a lot of papers to shuffle through, so bear with us, we'll get to it. So, sir, what's your name?
Jeremy Clicker.
And Mr. Klickner, what's your relationship and who's it with?
My family has employed all of David Kelly's children.
Okay. And what line of work?
Restaurant.
You still employ David Kelly's children?
His daughter's children.
And Mr. Klickner, let's see, what do you do for a living?
I work for Dr. Store.
Okay, is that where his children work?
Yeah, they work at the family's
Oh,
restaurant.
I'm sorry, that's what he said, not wrong.
And my dad goes to church.
Okay. Same question I've asked before, I mean, that relationship you got with David Kelly, Adams County's not on this case, would it give you some pause discussion with David Kelly that came up about what the verdict might be?
Sure.
Think you'd be fair to the state of Ohio and to the defendant?
For other reasons.
And what are those other reasons?
I'm foster parent.
Okay?
I am a childhood caregiver.
Okay. And we can discuss that more in private if we need to, so I appreciate that. So, thanks for your candor. I know that's not easy to talk about, but based on your experience and what you've gone through, you think it'd be difficult for them, is that fair to say? Okay, anyone else? I saw a couple of hands, and sir, you are Mr. Simmers?
Yes, sir.
Okay, and what's your relationship with him?
With Chris, he was a golf course for my son a few years ago.
How many years ago, sir?
I believe two. And then my son, Barbara, was my partner.
So Barbara Moore. How often do you see Chris Blanton? So that shouldn't cause you any concern. Barbara Moore. Oh, very good. I know I saw at least one of them. What's your name, ma'am?
Linda Worley.
Okay. Miss Worley,
I've known Jim Armstrong since high school. We're in a historical society together. We work on projects together.
okay. And are you still in that historical society with? Are you still in that same historical society with
Yes.
Armstrong? So you've heard some of the questions I've asked the others, ma'am, so you think you can be fair to the state of Ohio and to the defendant
I think so.
based on a relationship? Not that Ken Armstrong's ever going to talk to you about it, but wouldn't give you
I don't
pause?
discuss any of that with him now.
Okay. All right, very good. Thank you, ma'am. Who else do we have?
Mr. Rabel?
Yes, sir.
Tom Reed, when I work with Chris Blanton's wife, but I've never even met Chris.
Very good, I appreciate that, thank you. Anyone else in the first two rows?
In the back row there.
Yes, sir.
I obtained insurance from David Kelly.
Okay.
Would you identify yourself for the record, sir?
Gordon Francis.
Thank you.
All right, so Mr. Francis, you attend church with David Kelly. Is that every Sunday?
Every Saturday.
Good for you. Again, same question, any problem? Again, David Kelly's not prosecuting this case, it's State of Ohio represented by Scott Rod and myself, but no problem for you? Okay, very good. Anyone else? Yes, ma'am. And can you identify yourself, please?
Carol Baker.
And Ms. Baker, talk to me about your relationship with, who's it with, and
Barbara Moore. She did I think it was an eviction prep for me, several years ago. That's when
that was several years ago. You've not seen her since then? Okay, so that's not going to cause you any problems, is it? Okay. Anyone else? Very good. Okay, so now we're going to go over a list of potential witnesses, and I expect you to know some of these folks as well. And again, what's going to be important, if the fact you know these will impact on the ability to be fair and impartial, and how you know them. So just kind of listen to this list of witnesses. From the state of Ohio, Joni Hughes. She is the cousin, and the victim in this case is Ryan Applegate. We'll get to that in just a moment. Let me give the whole list. So, Joni Hughes, cousin of the victim. Angie Day, who's the aunt. Becky Armstrong, works for Manchester Schools. Brianna Wisecup is the mother of Ryan. Wayne Wisecup is Ryan's grandfather. Dr. Edward Connor is a licensed psychologist, has an office in Erlanger, Kentucky. Ryan Applegate, who is the victim. Kenneth Dix, Adams County Adams County investigator, works for the prosecutor's office. Special Agent Shane Hanshaw from the AG's office, Ohio Attorney General's office. Cecilia Freihofer, works at Cincinnati Children's Hospital at the Merison Center. Dr. Ellen Duma, also works at Cincinnati Children's Hospital. Bruce England, works at Adams County Children's Protective Services. And John Rothlow, who's a counselor, works for Chatco Behavioral Services. So, may we approach?
You may.
Just a small side note, I think it was probably just an error out of accident, but can we please have the victim referred to as the alleged victim?
Okay. Alleged victim.
I'll just call him Ryan from now on.
Yeah. Oh, Ryan. Yeah, that's fine.
Okay, so we've heard the list of the potential witnesses. Anybody having conflicts, know those individuals, so give them pause here today. Ma'am, what is your name?
My name is Tina Paul.
Ms. Paul?
P468.
Third page.
112370.
Let me just find you on the sheet, ma'am. I apologize. Okay, Ms. Paul, so who do you know and what's your
I
issue?
know Becky Armstrong. I work for the Manchester Local School District, so I know the child involved and also the people that work for Manchester Local School District. Also Joni and Angie, because they're from my hometown.
So you know Ryan as well, you indicated?
Yes, I
Have you formed any preconceived notions about this case?
do. No, really, I didn't know.
And again, I don't want you to talk about what you know, like the judge
No.
told you, but
Don't know at all.
those relationships, ma'am, and the fact that you still work at Manchester
Yes, I
Schools,
do.
would that cause you problems going back in the fall, regardless of how this verdict comes out?
No.
Think you can be fair?
Yes.
Who else? All right, I'm just going to go to the front row. Sir, give me your name, please.
Rodney Yates.
And Mr. Yates, whom do you know? Okay. Have you formed any preconceived, you have any preconceived notions about this case? And again, I don't know what those notions are, but do you have it? All right. Let's just talk.
Be honest.
All right. Let's just talk specifically about the ability. What did you do for Manchester Schools?
I'm a custodian, but I was the bus driver for Ryan, the pastor.
Okay. As you sit here today, you think those relationships will cause you problems going forward? They're not relationships, the fact that you know those individuals?
I'm not sure.
When was the last time you saw Ryan?
It's been a little while.
When you say you know the whole families that we indicated, when was the last time you saw Brianna?
It's not been a year.
You know,
I don't see the family a lot. I just know I was friends about years ago.
right. Listen, I appreciate it. I mean, I'm from Georgetown, Ohio, so I know people know a lot of people. West Union, Manchester, Adams County is a lot like that, so I know people know a lot of people, and I can understand that. It's important for us to make sure that we have, at the end of the day, a jury of 12 to be fair and impartial to the state and also to the defendant. So we'll maybe flesh out that preconceived notion maybe a little bit later, but I appreciate what you're telling me here today. Again, sir, you are Mr. Yates? All right, thank you. Okay. Yes, ma'am. I think you indicated previously that, are you Miss Hughes? And the defendant was once married to your aunt, is that true?
Yes.
And who's your aunt?
Gaffin.
And I believe Paula Gaffin is on the defense witness list as well.
I'm also related to Joni, who's an APA of my cousins. And I work for Manchester School also.
Ms. Hughes, have you talked to those individuals about this case? Before you-
Joni or Angie.
Joni, Angie, Paula?
That's
Okay, thank you. All right. Yes, sir.
I know Brianna from school, that's the only way you can do a couple of years younger. I have the seniors in school. I graduated in 95.
And you are Mr.
Simmers.
Thank you. And ladies and gentlemen, I would apologize that you give me your name, but having 36, and I'll do my best to remember your name when you tell me, but I had asked you again, and I apologize for that. So, all right, so you knew Brianna from school? Haven't really seen her since? All right. Sorry, and I appreciate it.
I know Bruce from
Okay.
For the record, it's Mrs. Click. Folks, if you would, each time you raise your hand, identify yourself, because we're keeping a record. We need to know for the record who the person is talking. So you're Mr. Clickner. All right. Sorry to interrupt, but go ahead.
Right behind Mr. Klickner, over his right. So what's your name, sir?
My name's Michael Lucas.
And Mr. Lucas, you were married to, at one time the defendant was married to your cousin, is that correct? And what is your cousin's name?
Paula Gaffin. Jenny and Angie are also my family members, cousins. My kids go to school with Ryan.
Have you talked to Paula or anyone about this case? Joni or Angie?
No.
When was that divorce, sir?
Excuse me?
When was the divorce, do you know?
I don't know exactly that.
How often did you have contact with the defendant during that marriage?
Not so much with Kevin, but I mean, we're pretty close-knit family, you know, Paula and Denise, my aunt, and my cousin Shannon, Ryan and Missy. We were all together every weekend. So.
Do you have any preconceived notions about this case? Again, not what they are, but
Yep.
Okay. And we'll talk about those, okay? And again, you're Mr. Lucas. Thank you, sir. Who else? It's easy in the front row.
My name is Denise Sims.
Thank you, Ms. Sims. So, who do you know?
I am, my sister is married to a Hanshaw. I don't know if it makes a difference. Brenda and Harold Hanshaw.
All right. Do you know if,
No, I do not know.
Okay. They're just Hanshaw in your family, essentially.
That's my sister and my brother-in-law.
Okay. Fair enough. And ma'am, you are Miss Davis?
Yes.
Okay. Who do you know?
Gaffin. I worked with her for a short time at Thomas.
And when was that?
Probably in 2015. It was for a short time.
Okay. Have you spoken to her since?
No.
Did Ms. Gaffin ever talk to you about her relationship with the defendant?
No.
Ever talk about the divorce? Who else? And ma'am, your name, please?
Chance Matthews.
Miss Matthews, who do you know?
I live in Brianna Lane and close friend
I didn't catch that last name. Who was it? Okay, thank you.
And you're close friends with Dwayne's ex-wife, Brenda? And how do you know Brianna and Wayne, I guess?
I ran it through the bottom of my sister when I was before I retired from the hospital. This was in my I've been running for years. And Wayne was one. I saw Brandon and Brenda probably 3 years ago and they're dismissed.
So Ms. Hughes, that was, I'm sorry, that was, Ms. Matthews, that was 2 or 3 years ago that you saw them? When was I talking, when was I going to talk to Brenda?
Just about 3 years ago. She and Brandon.
And you haven't talked to her about this case? Who else? Okay, we're good. Well, now we're going to start getting into some of the questions that the judge talked about. Again, the judge will instruct you on the law. But I'm going to go over a number of things and make sure that we pick the right 12 people to listen to this case. Everyone's entitled to be a juror, but you may not be the right person for this case. Make sense? And sir, with the earphones, can you hear me, sir?
Not really?
Okay. You're not in the first 36, but I thought I should just ask. So you're having difficulty hearing, sir?
I can't really understand anything that's been said.
All right, well, fair enough. I appreciate that. I'm not sure we can rectify that, but thank you. Now, ladies and gentlemen, this is a criminal case. It's not a civil case, it's a criminal case where the state has a burden to prove this case beyond a reasonable doubt. The fact that this is a criminal case, does that impact on one's ability to think they can be fair and impartial? You go with, sir right here in the blue t-shirt. What's your name, sir?
Peter McCoy.
And Mr. McCoy, you have no problem sitting in judgment of someone?
No.
I mean, our whole life we're told to not to judge, but you understand that being in here this week, it's going to be your duty to judge. You can do that, sir? That's not a problem for you? Now, you're going to hear some graphic testimony in this case. Like every case when it involves a allegation of a rape, sexual battery, there's going to be graphic testimony. You're going to hear words that are going to be offensive to you. Does that cause a problem for anyone? Ms. Sims, is it? I
Yes.
see you shaking your head. What issues that raise for you?
I am a victim
Of
of a child.
Sexual assault?
Yes.
And we can talk more about that in private, but you believe that, first of all, was the person who perpetrated that abuse on you, was that person prosecuted?
No.
And again, ma'am, if you're uncomfortable and don't want to speak in front of everyone, just let me know. Is that where we are right now? I'm going to stop right there. I appreciate it.
Well, actually, counsel, if you can inquire just as to what effect that may have,
Okay.
that's really the issue here.
All right, I appreciate it.
Go ahead.
Thank you. Are you indicating, ma'am, that because of that, what you went through, because you have difficulty sitting here this next week and judging
Yes.
fairly?
Yes.
Yes, ma'am. And Miss,
Sorry, I didn't get the name, what?
Freedom Baloo.
Okay, I couldn't see who was answering. Thank you.
all right, Miss Baloo,
I've also
You may.
This always happens. I know we kind of talked about it. I don't want to make someone sit here and have an emotional breakdown. So if it's okay, if there's no objection, I don't think we'd have any problem excusing her. She's having a hard time.
Which one you're talking about?
The one who just talked about being sexually abused.
Yeah, that's what I did
That's
last
what
week.
Sims-
So
I don't
just go
wanna-
ahead and move
I don't
on.
want to have
Right,
people be.
right. But basically, when you get to these things, just basically say, well, is there anything about that experience that you feel would render you unable to be fair and impartial? Most of them are going to say yes. If they say no, then at that point we might get into more specifics.
Okay.
All right. That was in private. Yeah. All right. Thank you. Continue.
I think based on our discussions with the bench, I think the state has no objection. I think the defense has objection to excusing Ms. Sims from cause and thanking her for her service.
Thank you.
You're excused. Go ahead.
Thank you, ma'am.
Denise Sims, number 413.
So, ma'am, I'm sorry. Your name again, please? Ms. Baloo, the perpetrator of the offense on you, was that a family member? Based on that experience, were you able, you sit here, to be fair and impartial to the state and to Mr. Gaffin?
I didn't hear that, ma'am. Okay, thank you.
And we'll talk, she said no. We'll talk more about that now. Ma'am, did you report that offense? So no one was ever prosecuted, is that true, ma'am? Are you comfortable talking a little more about that issue now, or would you rather we do it in private? Okay.
Well, counsel, rather than talking about the particulars, let's talk about the issue about her ability to set that aside and decide this case based on the evidence and the law.
Okay, and ma'am, and I appreciate Judge, thank you. And you understand, ma'am, the facts of what happened, you are separate from the facts of what happened, well, allegations in this case, and you'll be able to separate those?
I don't know if it would, like, I think it would, but I have to give
Can I ask you, were you an adult or a child?
Actually, twice once as a child.
Did you have specific reasons, ma'am, why you didn't want to report that? At the end of the day, did you ever report it to anyone, ma'am? And you've indicated, I appreciate your honesty and your candor, that it may give you some difficulty, but as you sit here, you do your best to separate the facts of what happened to you with the facts of this case, the allegations of this case. Anyone else facing a criminal case alone? Now, we've already gone through a little bit of this, but obviously some of these questions get uncomfortable. Certainly not our desire to make anyone uncomfortable, but again, it's our goal to see the jury to be fair and impartial. Who in here has ever had to hire someone, been involved in the hiring process? Sir, your first name again? And your last name? And you've been involved in hiring someone? And how do you go about doing that?
Interview, try to find out a little bit about
Right.
if they're qualified for the position, and see if they're the right fit.
Right, because although this person you interview may be fit for one job, it may not be fit for the exact job you're looking for. Is that right?
Yes.
Right, and that's the same thing we're doing here, ladies and gentlemen. We're trying to find someone for the right fit for this jury. Okay? Prior jury service, anyone been on a case? And ma'am, your name again?
Linda Worley, 467, I've been on grand jury before, I'm on jury.
Okay. And then, obviously, Ms. Swirl, you were not involved in the grand jury in this case?
No,
Right. What type, I'll be right with you, sir.
that's been some time ago.
What type of case was the jury
I
trial?
remember the grand jury was a murder case,
Okay.
and pettit jury, I was an alternate jury, it was an assault.
And you recall what the verdict was in that case?
They found the defendant not guilty, but because I was the alternate juror, I was dismissed and I didn't have to be on the decision.
Yes, sir. Front row, your name again, sir?
Rodney Yates.
And have you been involved in a jury trial, sir? Grand jury? Okay. What was that process like for you? Why did you think it was unfair, sir? Right, so if those are rules and that's the law, even though you didn't agree with it necessarily, just like in this case, there may be some laws or some rules that you don't agree with, but when you follow the instructions of the judge, even though you may have a personal disagreement with it, you understand to be your role here today. For example, as we drove in here today, we may have all chosen to exceed the speed limit or follow someone too closely. That's your choice outside of these walls, whether or not you want to follow the law. But if you sit in this box for the next week, you're sworn to follow the law. Do you understand that difference? You may not agree with it, but you're sworn to follow it. For example, this is not a case about drugs. A lot of people believe that drugs should be legal. Or marijuana should be legal and other drugs should not be legal. But what you believe, what the law should be, is different than what you'll be instructed here in this week. Understand that? Any other individuals involved in the black shirt? What's your name, sir?
Aaron Swackhammer,
And Mr. Swackhammer, what type of case were you involved in?
pettit jury, workers' comp.
And that case, what was the resolution? Was it found that the individual had an injury or no injury?
No injury.
And you were involved in those deliberations?
Yes.
How did you find that process? Fair, unfair? Serving the green shirt on the end, what is your name?
Robert Hitt Jr.
Mr. Hill, what kind of case were you in?
I was a grand jury for Adams County back in early 2000. And back in the upper 90s, I lived in Brown County and was jury interviewed for the Whitey Hoop murder case.
I'm sorry, the what murder case?
I believe it was Whitey Hoop.
When you say you were interviewed, so you were on a jury panel, but you were not selected for the jury service?
I went through this process and then had to go back again, and they had the 12 in the box. And then they interviewed from there, and when they dismissed one, I was like the third one in line, so I did sit in the box of 12, but I was dismissed.
How'd you find that process?
Oh, the grand jury, I enjoyed it.
Okay, very good. What other hand? Yes, ma'am, your name again, please?
Ruth Moore.
Miss Moore, what kind of case were you in?
I've served on the grand jury and the pettit jury.
What type of case was the pettit jury?
I don't recall, really. It was a long time ago.
You know if it's a criminal case or a civil case?
It was civil.
Okay. Did you actually deliberate?
Yes.
And you know what the result was? They find someone liable, not liable?
Guilty.
Okay. Anything about that process give you concern about sitting through this criminal trial?
No, nothing. It was fair.
Who else? Yes, sir. Name again, please, just for the record. I'm sorry?
Sean.
All right. What kind of case were you in, Mr. Simmons? And when was that? And did you actually deliberate? And what was the finding, if you recall? Hung jury? Do you recall what type of drug case it was?
I believe possession,
What was the issue in the case, if you recall?
such as,
Well, it was a hung jury. What were you?
there was some of us who, several one was saying guilty and you were saying not guilty.
Okay. Who else? Yes, ma'am. Right in front. What's your name?
Patricia Crawford.
Ms. Crawford, what type of case were you in?
It was long ago.
Okay.
There's no respect.
You don't remember if it's a criminal case, or did you actually deliberate?
Yeah.
You don't remember the finding? And Mr. Hayslip, Ronald Hayslip?
Yeah. I was involved in a case, it was up in Clinton County, Wilmington, in the mid-90s, a criminal case, and I was in the jury. And they found the defendant not guilty.
Not guilty.
He threatened the clerk at a gas station.
And that was in, would you say, the mid-90s?
Yeah.
You feel it was a fair process?
Not for him, it wasn't fair for the person that he threatened.
Wasn't fair for the person threatened?
He got off. Threatened the clerk in the gas station.
Now, you deliberated,
Yeah.
correct, sir? All right. So at the end of the day, you also voted not guilty?
I did not vote guilty. I was only one out of the whole group. He got off.
Who else? Yes, Miss Karen Grooms? Yes.
Grand jury, it's just where we had cases and to see if it was enough to prosecute.
Do you feel like that process was fair? You understand if you're selected to sit in this, the jury panel, it's going to be your job to listen to the testimony and evidence and apply that testimony and evidence to the laws as the judge instructs. We talked about the difference about what you do outside the courtroom and what you do in here. Everybody understands that, and everybody's okay, they can do that. I appreciate that. I want to talk a little bit more about following the law, even if you don't necessarily agree with it. Make sure that we understand the difference. Anybody have a problem with that and understand my kind of hypo with the speed limit as opposed to what happens here today? Now, the state of Ohio has a burden to prove this case beyond a reasonable doubt. We embrace that burden. The state of Ohio has to prove beyond a reasonable doubt that each and every element of the crime and nothing more. So what doesn't the state have to prove? Motive? Does anyone believe that the state should have to show some type of motive for this offense? Miss Davis, I understand it's just about the elements and the laws the judge instructs, but we don't have to prove motive. Now, a couple people indicated they know some of our potential witnesses in this state's potential witnesses in this case, who, sitting in front of me, has heard something about this case, whether in the newspapers or whatever the case may be, through friends or family members. Anyone? A few hands. We'll work our way down. So, Miss Davis again, correct?
Yes.
All right. Now, and again, I don't want you to talk about what you've heard, but based on that, would it cause you some problems in sitting here today and being fair and impartial?
No.
You can listen to the evidence and
Yes.
you don't have a preconceived notion about this case at all? Who did you talk to about this case?
I have talked to my husband. He knows of somebody that was just telling him about it. So, just my husband.
Read any newspaper articles about it?
I haven't read anything.
Now, do you know who your husband's talked to?
Yes.
Who did he talk to? Do you know who your husband's talked to about the case?
Yeah, I do know. Is it possible that I could talk to you one-on-one about that?
Well, it is possible, but why don't you inquire further about the effect of that, so forth.
Okay, so there's some reason you don't want, and I appreciate that, I understand, there's some reason you don't want to indicate who that person was in front of everyone else?
Oh, okay. His real name's Jason Howard.
Jason Howard? Okay, is there a reason that, I don't know Jason Howard, so,
I believe, if I'm not mistaken, I think that he rents off of him.
I think Jason Howard may rent from Kevin
I
Gaffin.
believe, if I'm not mistaken. I just don't have the facts straight, but I don't know.
All right, thank you, ma'am. I think you already indicated that that's not going to give you, that's not going to stop you from being fair and impartial. Right? So let's just talk about this because again, I know that, you know, West Union, Manchester, it's a small town where I'm from. Has anyone spoken to Kevin Gaffin about this case that sits in front of you? How about individuals who know Kevin Gaffin? What's your name, sir?
Mr. Griffith?
I'm sorry?
Richard Griffith,
And how do you know him, Mr. Griffin?
works around me, and him and his brother both.
You still work around him?
Uh,
When's the last time you worked around him?
Probably 3 years ago.
What type of work did you do?
I got working on the river down there, yellow, he was on the shutdown.
Never talked to him about this case?
No.
Who else? Again, sir, say your name just so we're clear.
Rodney Yates.
Okay, Mr. Yates, how do you know Mr. Gaffin, the defendant?
Acquaintances, I know him from Manchester. I live in Manchester.
Okay. Never talked to him about this case? Talked to anyone about this case? When you say yes, some preconceived notion, we'll talk about those. Who else? Ma'am, state your name.
Emily Hughes,
And Ms. Hughes, how do you know the defendant?
she was very sweet.
I'm sorry, yeah, you said
And
that.
then both his kids are my cousins, very close.
All right. Okay. Yes, ma'am.
Rebecca Kirkwood. And Kevin is the first cousin of one of my husband's really close friends. And he also has played on both of them as my husband in the past.
Ms. Kirkwood, would it give you a difficult time to sit in judgment of someone that you know? I'm sorry?
I don't know.
And based on that relationship, it would be hard for you to
Well,
find the defendant guilty. That's what the evidence showed.
it's really, I really don't have a relationship with Kevin. It's just, I know him through those meetings.
But the same
I don't
question,
know him at all.
the same question, if you believe in this case the state has proven each and every element of these offenses without reasonable doubt, can you sit in judgment of the defendant? And Mr. Yates, how about you? Who else knows Mr. Gaffin? Sir, your name again?
It's Beer McCoy.
And Mr. McCoy, how do you know the defendant?
I just know friends on the
Socialize with him at all?
a few times.
When was the last time you socialized with him?
It's been well over a year ago.
You ever talk about this case with him? Same question to you. Any difficulty sitting in judgment of the defendant based on the fact that you socialized with him in the past?
I don't believe so.
Yeah.
I don't know. I mean, it's a tough question. Very much the case is.
But what you're saying is you'll listen to the facts and evidence and apply the laws the judge instructs?
Yeah.
Who else? Ma'am in the back, state your name.
My name is Tina Hall, 8468. Our sons grew up together and played baseball on Sunday for several years.
Now, Miss Paul, we're not going to get into the facts of this case, but obviously you've heard what the indictment includes: rape and sexual battery and felonious assault. Based on those facts alone, does that cause you a problem sitting in judgment of the defendant?
It makes me uncomfortable being a child involved since I work with children. I personally with school and I work with a lot of children. And when I'm doing this child represents disorder, so it does make it uncomfortable.
Who else indicated that they know the defendant? Yes, sir. State your name for the record.
Ryan Hazelbaker.
Yes, sir, Mr. Hazelbaker.
I had his children in class.
Would that cause you a problem sitting in judgment of the defendant again with the nature of these indictments?
I don't believe so.
Now, a number of people have indicated that, very, very candidly and very fairly about the difficulty they have sitting in judgment of the defendant. We understand there's an alleged victim in this case, and it's Ryan Applegate. So I want to make sure that there's no one in here sitting before me that, because of the relationship they have with the defendant, would not give Ryan Applegate the attention and the fair and impartial verdict that he deserves. Everybody understand that? There's an alleged victim in this case, is Ryan Applegate. He's not before you today, yet just the defendant is. I understand that communicating to be fair and impartial to the defendant, Kevin Gaffin, but Ryan Applegate deserves that same consideration. You understand that? Now, ladies and gentlemen, we're going to go over a number of legal terms, and the judge is going to instruct you on the law. That's not my job, but we need to talk about just a few issues. You've heard me say already, the state has proved this case beyond a reasonable doubt. Anyone know what that means? That's a legal term. Anyone know what beyond a reasonable doubt means? Does anyone believe that beyond a reasonable doubt means without a shadow of a doubt, without all doubt? So I see a couple of heads going up and down. Mr. Hayslip, do you think beyond a reasonable doubt means beyond a shadow of a doubt? What if I were to tell you, and the judge will instruct you, that beyond a reasonable doubt means that if you are firmly convinced, of the elements of this case, the state has proven the case beyond a reasonable doubt. Does that make sense to you? So, it's not beyond all doubt. Why is it not beyond all doubt? Who can tell me why it's not beyond all doubt that the state has proven this case? Sir, what's your name in the blue shirt in the back?
Tom Reed.
You understand why is it not beyond all doubt, sir?
I went there, I went
Okay. But in human affairs, right, everything's subject to some doubt, right? Is that fair? Does that make sense to you? So what's your name in the back with in the gray shirt?
Roger Fetters.
Mr. Fetters, you promise to hold the state to the proper standard in this case, beyond a reasonable doubt, not all doubt? Okay. Remember right here in the I'll call the pink shirt. What's your name again? Okay. And ma'am, you've heard me talk a little bit about beyond a reasonable doubt and the difference between without a shadow of a doubt. So if you look to the left of the courtroom there, you see that what appears to be, what is that?
The flag?
Yeah, what type of flag is that? Are you firmly convinced that's the American flag? Why is that? All right. Because it's reason and common sense, right? Now, are you convinced beyond a shadow of a doubt that that is the American flag? But isn't there potential you can unfurl that flag and it could have red and green and other colors in it? We don't know that for certain of you because you can't see the whole thing, right? But you're firmly convinced that's beyond a reasonable doubt. But there's some doubt, right, that there could be something else, right? If you unfurl it, it could be an Italian flag, right? And Mr. Sims, you understand that, right? Mr. Dean, I apologize, we switched around. So Mr. Dean, you understand what I'm talking about, right?
Yes, sir.
So what are we asking you to do? Use your reason and common sense. Because all things in life are subject to some doubt. Even that American flag, you pull it out, maybe it's something else behind. You don't see all 50 stars, right? You don't see all 13 stripes. Is everyone firmly convinced that that's the American flag? But there's some doubt, right? And sir, in the blue shirt again, your name again?
Tom Reed.
And sir, you said something about you didn't see it, so you don't know. Do you believe, sir, that you have to see something to believe it beyond a reasonable doubt? To be firmly convinced of something, do you have to see it personally?
Yes.
You do?
Yes. Too much falseness and liar in this country.
Okay. So if you didn't...
Exactly.
So if you
Don't make
didn't-
any comments, folks, unless you're being asked a question. Thank you. Go ahead.
And so listen, hey, I appreciate your answer, I appreciate your opinion, and there's no wrong answers here, and you're absolutely entitled to what you believe. There's nothing wrong with that. But I want to talk to you a little bit more about that. So what you're saying, sir, is if you didn't see something, you can't be convinced beyond a reasonable doubt that it happened. Is that true? Okay. And give me your name again, sir. I'm sorry.
Tom Reed.
All right, thank you, Mr. Reed. Now, Mr. Reed, let me ask you this. You, I think, are currently a victim in a break-in, is that right?
Yeah.
And did that occur in Adams County?
Yeah.
And can I ask you a little bit about that?
Sure.
Okay. Is there an investigation?
Well, much investigation we caught him.
Oh, you caught him right on the spot?
I did. My neighbor did.
Okay, very good. Has that person been prosecuted?
Not yet. Do it whenever.
Okay. All right, very good. Anyone else think they have to see something in order to find someone guilty beyond a reasonable doubt? Yes, ma'am. What is your name?
Carol Baker.
Okay, Ms. Baker, so you also believe that unless you see it, you can't be convinced?
Not necessarily. We use the flag,
Yes.
and I can look at it and say, yeah, it's our American flag.
That's based on your reason, common sense, and life experiences, right?
That's my looking at it like that, yeah.
Right?
But if I had any doubt of it, I would say, okay, let me see all of it.
Right. But even though it hasn't been opened, as you sit here right here today, based on the facts that you have before you, are you firmly convinced that is the American flag?
Yes.
You don't need to see anything else, do you? Again, it's not beyond all doubt, man. I'm not asking you beyond all doubt is that the American flag, because there's always some.
Right.
But you're firmly convinced that's the American flag.
Yes.
You understand? That's the standard which the state has to prove. It's not beyond all doubt. You're firmly convinced
All right.
that the state has proven each and every element, because everything is subject to some doubt. Anyone else believe that they have to see it in order for the state to approve it? Now, as potential jurors, ladies and gentlemen, you will be the sole judges of a witness's credibility. The judge will tell you that you can determine an element of offense based on a sole witness's testimony. It's not about the quantity of the evidence, it's the quality of the evidence. It's not about how much evidence the state puts on, it's the quality of the evidence. And how do we judge someone's credibility? How do we tell if someone's telling the truth or not? I have to pick on someone if I don't get it wrong too. All right. Sir in the back, staring right at your glasses. What's your name, sir?
Reese Adams.
And Mr. Adams, how do we judge someone's credibility?
Well, you can't really tell if they're telling you the truth or not. If somebody looks straight in the eyes, it's so likely.
Okay. And
You kind of have to face a lot of their movements, things like that.
so their demeanor, body language.
Body language is a big one.
Okay. You have children, sir?
Yeah,
How many children do you have?
I have two former married, and I have three with married ones.
And how old are those children, sir?
The three that I have now are stepchildren. They range between the age of 27, 23, and 11. And I had a 28 and 24-year-old. I have a 6-year-old grandson with a grandchild on the way.
And did you have the opportunity, while those children growing up, to judge their credibility about something?
Oh, yeah.
And how did you do that?
Just based on the facts that what you see is what
Reason, common
basically
sense?
how they acted.
You understand that, well, let's skip that for a minute. Who in here has been in a traffic accident? And ma'am, right in front of me, the black top one, what is your name?
Presley Berry.
I'm sorry, to your left, to my
Mary Jo
left.
Baumgartner.
I'm sorry?
Mary Jo Baumgartner.
Ms. Baumgartner, when were you in the accident?
Probably 20 years ago.
Okay. What type of accident was it?
Someone bumped into me.
What color car was that person driving?
I have no idea.
What day was it?
Like a day, like a weekend, work day.
Okay. So Ms. Baumgartner talks about being bumped. She doesn't know the day, doesn't know the color. Sir, what's your name in the black shirt? Your name again?
Aaron Swackhammer.
Mr. Swackhammer, do you think she's lying about being in an accident? Why not?
There.
Because she didn't know the color of the car.
It was 20 years ago also.
Okay. Doesn't know exactly what day it was, right?
Right.
But you believe, you're convinced, beyond a reasonable doubt, that she was in an accident, right?
Says she was.
So my point is that there may be some facts that are forgotten over time. Who else was in an accident? And I'll go with you first, ma'am, Miss Grooms. And when was your accident?
2 years ago.
Okay, and what day of the week was that?
That was on a Thursday.
Okay, and what color was the car?
There was two I was sandwiched in between. One was a red truck in front and a black Jeep in the back.
Did the police force respond? What's the name of the officer? Okay. Does anyone doubt that she was in an accident even though she couldn't remember the name of the officer? As a judge of the witnesses, you have the right to believe some, all, or none of all the witnesses' testimony. And I'm asking you to commit that if a witness can't remember a portion of a specific fact, that you want to automatically discount that entire witness's testimony. You can, that's your call. But understand, just like these two accident hypos, some facts over time change or not remembered. Now, man, you certainly remember you're in an accident, although you don't remember the certain facts, right? Very good. You understand that this customer was under oath, you don't have to believe them, right? Maybe 40 years ago, it was a different time, but today, this customer testifies, doesn't mean you necessarily have to believe what they say. You're the judge of that credibility and their testimony, and you believe, disbelieve, believe everything they have to say. And again, remember, as this week goes along, about these two hypos with the accident and not being able to remember all those facts specifically. Doesn't mean it wasn't an accident, just can't remember everything specifically. There's two types of evidence the judge will instruct you on. I won't spend a lot of time on that, but there's direct and circumstantial evidence. That evidence is the same. You weigh that evidence the same. Again, it's up to you. But direct evidence would be if you walk outside and you see that it's raining. Understand that? You have first-person account of what happened. You see it's raining. That's direct evidence. Now let's assume that you don't see it's raining, but you look outside, you hear thunder, or you're sitting, assume you hear thunder. You walk outside, there are puddles. It's humid like it is today, and the ground is wet. That's what's known as circumstantial evidence that it has rained. Everybody understand that? Direct evidence is someone sees it happening, or it's before you. Circumstantial evidence is you base upon the facts that lead you to a conclusion. And the judge will instruct you on that. Now, while we're discussing evidence, there are rules of evidence that the state and the defense has to follow. And from time to time, you'll see us approach the bench and talk about maybe one of those issues. It's not because we're trying to hide something from you, but it's because we have rules that we have to follow. And you'll hear objections throughout this trial. Again, it's not we're trying to hide anything from you. Mr. Plickner? Mr. Plickner, you understand what I'm talking about there? That if you have objections, you promise not to wonder what was said or what that testimony might have been and to use that in deliberations. You understand you're to deliberate based on the facts and evidence that's presented to you, not to wonder what would have been said or what could have been said. Mr. Griffith, do you understand that, sir? Any problem with that? Now again, I've talked a little bit about the burden, but when the state embraces that burden, I make sure to understand that it is the quality, not the quantity. One witness, if believed by you, is sufficient to prove any fact. Anybody have a problem with that? Ma'am, in the floral shirt, what's your name? And is that, do you understand that? That if you believe one witness is sufficient to prove any fact. For example, if I have this whole box of potential evidence and you don't believe any of it, what should your verdict be? If I just present a notepad, and this notepad, and the evidence of this notepad firmly convinces you of each and every element of the offense of which the defendant stands accused, what should your verdict be? Anybody have a problem with that? Understand that? Sir, in my far right, second row, what's your name, sir? Larry Newman. You understand what I'm talking about, Mr. Newman? Now, what if there are two distinct versions of what occurred? One witness says this happened. There's only two witnesses that say it. One witness says this happened. One witness said that happened. Ma'am, right in front of me, what's your name? I'm sorry. Yes. Miss Crawford, again, one witness says this happened. One witness said that happened. There are only two witnesses. Different accounts. What's your verdict?
One against the other.
Does it depend? What could it depend on if there are only two witnesses? And there will be more than two witnesses in this case.
Well, it's not hearsay, and then there's just two witnesses.
Well, you understand that you'll could be the judge of the credibility of this witness versus this witness. You don't have to give them equal weight.
Right.
So I guess my question is, if there are only two witnesses, that doesn't equal, and they have different accounts, that doesn't automatically mean there's a not guilty finding, does it? Anybody believe that? Ma'am in the blue shirt, what's your name?
Jill,
All right. What do you think about that? Only two witnesses, there'll be more than that in this case, but two different accounts of what happened, only two witnesses. How would you reach your verdict in that case?
Putting on what's been presented, reasoning and the evidence that's presented.
Okay. And what else is extremely important that I've talked about? The evidence, applying that evidence to what? But you apply that evidence to the law, right? And the elements of the case the state has to prove. Everybody understand that? Any problem with that? Now you understand it's your job to determine if the state has proven this case beyond a reasonable doubt. And it's the judge's job to sentence the defendant if he is convicted. You understand, you're not considering what potential punishment could be in this case if the defendant is convicted. And I say this because I've had a number of juries that afterwards people struggle with that. You trust Judge Cobbs to do his job if the defendant is found guilty. You understand that's not your job? Certainly in the green shirt in the back row. You understand that, sir? Okay. You're not to consider what potential punishment might be. Ma'am, I'm trying to stare right at you with the glasses. What's your name? And you understand that, Ms. Young? Now you've heard what the indictments, how the indictments read, but that's the judge's job to worry about what potential punishment might be if you're convicted. Far left, sir, do you understand that?
Yes, sir.
Your name again, sir?
Robert Jr.
And we're doing that for the record so we know who everyone is. People struggle with that. It's okay if you do, but I want to know now if that's going to be a struggle for you. Anyone? Anyone sitting here and been unfairly treated by the criminal justice system? Sir, your name again?
Tom Reed, 2 years ago, again, same building, same location. Two or three gentlemen broke in. And I sold $1,500 for my business. They went through the court system, nothing was ever done. I still lost $1,500. Still running free.
They were charged.
One admitted that he didn't have a record, the other two. So he just took the rap. This was told by investigators, he took the rap so that they wouldn't get punishment. He got probation. I still lost the money.
Now this investigator, was it, you say it was an Adams County, sir? I
It was
apologize.
an outcome.
Who was the investigator in that case?
Kevin Cross, deputy sheriff.
Okay, so it wasn't Kenny Dick.
Well, I didn't get it. Dick, he might have worked with him, but they caught him selling goods to people.
Now how many folks were there?
There were three, Mr. Rogers eventually.
And you're firmly convinced that all three of them committed this offense?
According to the sheriff, said it was. In fact, I run a garage in the gas station. Mr. Rogers came back and said, "Did you hear the whole story? Did they tell you?" I said, "No." Not only did they break in the lab, they run out of gas, they come back, broke in again, filled up their car's gas, and
So based on what people told you, you're firmly convinced that they broke into your place, right?
Yeah, something like that.
Right. Do you think it's these individuals they told you about, true?
Yeah, that's funny.
But you didn't see them do it,
I
right?
didn't see him.
But still, based on the evidence, you believe they did it, right? And I asked you that because we talked earlier about, hey, if I don't see it, the evidence would be very, very, very good. But in that case, there's enough evidence to convince you that these people are the ones who did it, right?
But they admitted to me, to the sheriff, he told me.
All right,
They
very
admitted
good.
it to me.
I understand.
For sure.
And sir, do you think that everyone who commits a crime admits what they've done?
Do they admit it?
Yeah.
No,
Do you think the majority of people admit or deny it?
they did not.
And why is that?
There's always something to get out of it, right? Yeah.
Anyone else believe they've been treated unfairly by the criminal justice system? Now, I appreciate you've been a victim of crime, but that's the only 2 times, sir?
Yeah, basically.
Basically.
Yeah.
There's been a couple of hands. I know we had the issue with the abuse case, but who else has been a victim of crime sitting in the first 2 rows in front of me? Yes, sir. What type of crime? And were those people apprehended?
Well, some of the items were recovered.
They were prosecuted?
They were prosecuted.
How long ago was that, sir?
I pressed it, I called the prosecutor's office. Hey, I want something done. They just got
Does that experience, sir, give you some pause as relates to prosecutors in general? No, I understand that. Who believes that there should be scientific evidence before someone should be convicted of crime? Yes, ma'am.
My stepdaughter, she had been molested and never did go to court. There wasn't enough evidence, so
How old was your stepdaughter?
at the time she was,
Did she immediately disclose what happened to her?
she told me she lied.
Was this a family member?
It was my brother-in-law.
And that person was never prosecuted?
No.
Does that impact on your ability to sit in judgment of Kevin Gaffin, who stands accused of sex crimes?
No, I was that.
Who's ever watched a NCIS or CSI or Making a Murder? Who watched Making a Murder? NCIS, crime shows. And what do those shows always have? They're what? They're always wrapped up in what? I'm sorry?
Forensics.
Okay, and they're also concluded within an hour, right? You understand this isn't a NCIS or a television show. Not every case, we appreciate not every case is going to have forensic evidence. Does anyone believe that in the sex case there should be some type of physical or forensic evidence before the defendant should be convicted? You want to have that feeling? Why is it not always the case? And ma'am, again, state your name in case we didn't.
Carol Bay.
Why is that not always the case, Ms. Baker?
Well, I guess it depends on the situation. Like there are some women that are great, go home, clean up, you know, and any DNA or anything like that is gone.
Right.
So it just, I guess it depends.
So just because there may not be forensic evidence doesn't mean it didn't happen.
Right.
Anyone have military service that sits in front of me here today? Has anyone heard of the term post-traumatic stress disorder? Ma'am, in the back row with the black shirt, what's your name for the record?
Mary Jo Baumgartner.
Do you know someone with post-traumatic stress disorder?
Yeah, I was a psychotherapist, so I've had people I've counseled with PTSD.
And what kind of symptoms do they typically have?
Depression, not being able to sleep, being angry easily, what they call a startle effect.
What's that mean? What's a startle effect?
Well, if someone's sitting here and they're fine, and they hear a gunshot, or they hear a wreck, it takes them back to the war, or whatever the incident was that made them in PTSD.
So you said a war, what other instance? So there, in your experience, that there are people that have PTSD that weren't in a war?
Oh, yeah.
Did they exhibit the same symptoms of those that may have seen combat?
Probably not to the same degree, but
But-
most of the same. Not everybody has all the symptoms. Or they don't all have the same symptoms, but they have enough symptoms, no matter what the effect was, or what started it, give them the diagnosis of PTSD.
Who else has indicated they know someone that, you can insert your name for the record?
Michael Lucas,
And Mr. Lucas, who do you know that suffered from PTSD?
my cousin Dylan Hasty.
And was Dylan in the military?
Yes, sir.
And what did you observe about him, if anything, that was different between before he went to
Well, after
war and
his
after?
first tour of duty, when he came back, really didn't have any kind of, emotional issues, being angry or anything like that. It wasn't until after his second or third tour of duty, when he lost fellow members in the Marines, that when he come back, he struggled with depression and just being angry and stuff like that. And he's feeling better now.
So he was depressed, he was angry. Anything else that he still associated? Was he isolated?
Well, I haven't spent that much time with him since because he's moved to Texas now, but he's struggled with, being around people, at his job, things like that. So.
Who else? Raise their hand. And your name again for reference.
Jared Winter.
And who do
My
you know?
daughter, who we adopted, the foster system, she suffers with it, she has panic attacks, and has a hard time making decisions sometimes. Different triggers will kind of set her off in that.
What do you mean by panic attack?
Shortness of breath, sweats, almost like she would describe it as like constricted breathing.
Who else? And Miss
Baker.
Miss Grooms, who do you know that suffered
My
from PTSD?
father, he was a vet.
Do you know where he served?
He is passed now, but he served in Vietnam and many other
Okay. What type of symptoms did he have?
depression, easily angered, afraid of a lot of people.
I appreciate that, ma'am, and I appreciate your father's service. Anyone else?
Miss Baker back there on the street.
Ma'am, your name again? Miss Baker? Yes.
My husband suffers from PTSD.
And was he in the military in that?
Yes, he was in Vietnam.
And I appreciate his service. Were you married to him before he went to Vietnam? Okay.
My dad also suffered from PTSD.
I'm sorry, you were...
My father also
Okay.
suffered from PTSD. He was 13 years in the military. It can affect people in a lot of different ways. But it's the same thing, the depression, the anger, sometimes it's alcoholism. Sometimes it's run around cheating on your wife, it can be a sex addiction. It can be living out away from other people because it's just too much to be in a crowd. There's so many things that affect them, and affect my husband in that, but yet he can still go to work, he remodels, rehabs apartments and things like that, as long as it's a controlled environment. If anything goes wrong, then, you know, he says wrong. So people can function very well until that trigger hits, but that trigger is not really, although it's the same trigger.
I appreciate that. Thank you. Anyone else?
Excuse me, Mr. Miller, would you approach counsel?
Yes.
Been about an hour and 40 minutes. How close are you been done? And you're getting a little bit further afield than I normally permit.
Okay.
I just
Judge, I would
think
say
it's good time to wind up.
probably a half an hour, Judge, I'm thinking.
Another half hour?
Yes, sir.
Okay, we'll take a break then now.
All right, thank you.
Do I have to hit the button up here when you know the lynch mode? No. All right, ladies and gentlemen, we're going to take a break here. It's been about an hour and 35 or almost 40 minutes that we've been in here. So we're going to take a 15-minute recess. And what that means is with the number of people we have, it may run a little bit longer, but go ahead and relax and go to the restroom if you need to, get a drink. If you need to make any calls, let people know where you're at work or somewhere else, you can do that. Just make sure you turn your cell phone off before you come in. So as soon as you've stretched and whatever, if you come back and look around, make sure you memorize where you were seated so that you're seated in the right place. And we'll be back, let's see, I have about 10:40, so I would like you to be back in your seats at 5 minutes of 11. All right? And remember, during the break, not to discuss the matter in any way with anyone or permit it to be discussed with you by anyone. That includes talking about anything you've heard during it, people, topics, issues, etc. All right? 15. Thank you. Be seated, please. Counsel, if you'd approach, please. Okay. For the record, during the break, court consulted counsel and excused, I excuse these without consulting, number 547, Penny Day, next to last. She'd worked all night and been called back to work for emergency. Juror 523, Joyce King, has a major medical procedure Thursday, next to last page. I also excused juror number 492, Gaffin Jones, I believe, who's employed by the office of former Representative Mr. Gaffin. Excused juror number 417, Mr. Klickner, who's in the front row due to his numerous issues. And then I also, without counsel, just excused number 430, Janice McCarty, who was in the front row. I believe number 430. Her husband just had open heart surgery, and she's the only person taking care of him. So, and I'm going to inquire that. I have inquired that. I'll ask the jurors if there's anybody has any similar, they have a vacation plan or something this week. So, okay, thank you. All right, ladies and gentlemen, before I allow the state to continue voir dire, one thing I did overlook, I normally bring this up and I kind of got sidetracked on it, and that is that we are set to be here through the rest of the week. Any of the prospective jurors, and this includes everybody in the room, that has any vacation you're scheduled to leave on this week, or if you have any major medical appointments that have been planned for a while, or procedures, anything of that nature. Anybody have anything like that? All right, I see some folks back here in the back. Let me get my pen. And the lady in the pink shirt, your name? What's your number? 548. Okay, and you have a medical appointment? Okay. All right. Number 548, you say your number was? Okay, you're clear down the list, so I will excuse you. Just report to the clerk. I thought I saw another hand back here. Yes, ma'am. You're in the green shirt. Your name?
Ron Holsteiner, D540.
Okay.
Pre-op appointment Friday.
A pre-op appointment? Okay. I'll excuse you then. you're down the line, and also report to the clerk's office. Now, I'll work my way. Anybody else here? All right, in the second row over here, the lady in the gray shirt, your number?
P504.
And your name is Joyce Wilson?
Correct.
And it,
I have a medical appointment tomorrow.
okay. Is that a routine medical appointment or something that you've been, needed to take care
I
of?
had foot surgery and it's my post-op exam.
Okay, I'll excuse you. And report to the clerk's office. Anyone else over here? Right in the back row, clear in the corner. What's your number?
P472.
All right, Deanna Horsley?
Yes.
Okay,
I'm leaving for vacation Friday morning.
all right, vacation Friday morning. All right, I'll excuse you. Yeah, all right, anyone else here? All right, now we'll go to the back row, Mr. Raybold.
464, I have a root canal scheduled for tomorrow.
A what?
A root canal scheduled for tomorrow.
Would you rather be there or here?
Well,
I know where I'd rather be, I'd choose here.
I could probably get that rescheduled, but I would need to know sometime sooner rather than later. I'll try to reschedule that, but that is something that I have.
Well, I'll leave it up to you. We will probably go into the, we'll probably have a jury by 1 o'clock or so. Would that be enough time to make? All right, so you're willing to stay and be considered?
Yes, sir.
All right, thank you. Okay, and I'm sorry, Mr. I lost my place here. Let's see, you're before Mr. Reed. You're Mr. Lucas? Okay.
I have a dental surgery that's supposed to be tomorrow.
I'll ask you the same question I asked him. You want to have your teeth worked on or be in court?
I look
As a
like
juror.
I have my teeth worked on.
Okay, all right. That's a perfect example of what's known as a Hobson's choice. So I will excuse you. And report to the clerk. Okay, Mr. Reed?
458, I've got a doctor. I've been taking treatments every day for the last 3 weeks. And in fact, this week I got surgery again in a month. I don't want to.
Okay, well, are you scheduled then? You have to keep doing these treatments this week?
I take treatments every day.
Okay, and it's scheduled for the rest of the week?
Yeah,
Every day?
until I have surgery.
Okay,
I have to take it.
all right. I'll excuse you then. Report to the clerk. You can just go ahead. All right, so all those of excused, you can go ahead and report to the clerk and leave. All right, anyone else? Okay, in the front row, Mrs., is it Kirker?
Kirker, yes. I know it's supposed to go through Friday. I leave for vacation early Saturday morning.
Okay.
That's the only possible.
All right. Well, I can tell you that I'm going to do everything to make sure this is done, even by Thursday if possible. Okay? All right. Anyone else? All right, then with that, we'll turn the board here back over to the state.
Thank you,
Mr.
Your
Muller?
Honor. Before the break, we were talking about PTSD, and a number of people have known someone who has experienced PTSD, and we talked about the symptoms. But does anyone sit here and believe that your PTSD or psychology is, I'll throw out the phrase, junk science? It doesn't exist. The state's going to have a psychologist testify. You'll be able to listen to that testimony, but you won't believe PTSD is it's just somebody who can't handle something? You don't, is that what you believe? So you believe soldiers coming back from war, you just suck it up and move on?
My brother lost a leg in the war. Just good as anybody.
So you don't believe in PTSD? Fair enough. Now, if you hear testimony as it relates to PTSD based on your brother's experience, you not be able to set aside that personal experience and listen to evidence and be fair and impartial. You won't be on this jury, do you, sir?
No, sir.
Now, you indicated that previously that because of this losing the job and money that you could not be fair in this case. Is that true?
Yes, sir.
Now, you're going to hear testimony about the indictment and the sex type crimes. And I'm going to focus, if I can, just on the front row here because, at least initially, those are the folks that are going to be potentially in the jury. So I can focus and narrow down focus on that. We'll get into the back row as well, as where people be excused. But Mr. Hitt?
Sir.
Is there any one profile that would fit what a sex offender should look like?
No.
What does a sex offender look like?
Be any of
Is there a profile about what a sex victim should look like?
No.
Why is that?
Be anybody.
Who has young children? Anyone in front of have young children? And Miss Davis, how young is your child?
I have a 2-year-old girl and a
2-year-old and a 9-year-old? What's the most important thing in their lives? Their safety? And how do they feel safe? What's your name, sir?
Richard.
And say it again for me.
That's love.
And that you love them. Important they feel safe. Sir, blue shirt, you have one, sir. Mr. McCoy, can you think of a reason why someone may delay telling somebody about something?
Not sure how to handle certain parts of the situation.
What if that person's a child? What may delay that person from saying something?
They're not sure the reaction that they have from her. Probably confusion, I'm not sure.
When you say reaction, what are you talking about?
What do you mean?
When you say that they may not sure what the reaction would be, what do you mean by that?
As far as the reaction, I'm not sure what the consequences of the way they think they do something wrong. They're not sure who to play or what's going on. Confusion, what it is. Our question answered.
Understand? Because an issue is delayed in reporting or fully disclosed, sir in the black shirt, your name? Does that mean it didn't happen? What are reasons that maybe something is delayed in reporting or not disclosed immediately?
Timing, things going on,
Well, that person's a child.
they may not know what to do.
What do you think is the most important thing for a child? You've heard the young lady to my right indicated safety. What do you think about that? And if a child's safety may be at risk, what do you think that child may not do?
They may not speak of the situation.
Who here has been, and we talked to some individuals, I appreciate that. Let's strike that. Let me go back, Mr. Yates, sir. You indicated previously that you had some preconceived notions about this case. True? Now the question, I guess the main question I have to ask, but I want to ask the board is, can you set that preconceived notion aside and be fair and impartial in this case? So the try isn't the sand. You can appreciate that.
Well, I mean, what I was going to say, I've heard a lot from one side.
Which side did you hear from? So, as you sit here today, the preconceived notion, again, I mean, I try to flesh it out a little bit. It's important for the state, it's important for the defendant. You set that aside. I know you said I tried, but you tried.
I guess depending on the evidence, I can't tell you. I'm just trying to be honest.
I understand that, sir, and I appreciate that.
It depends on the evidence, it's different when I change my mind when I think happened. I've heard things, I noticed things.
Does anyone have any preconceived notions about sex abuse of children? Either doesn't happen, ma'am, in front of her?
Oh, yeah, it happens.
And your name again?
Patricia Crawford.
And you think all those abuses go reported immediately? Or you think they're reported immediately?
No,
And why are they not? Why would they be?
it could be shame, guilt.
How about if it's a young child?
They might go and tell anybody or they
To go back to the safety issue?
would. Yeah.
What do you believe is most important? Do you have children? When you were a child, if you recall, a few years ago, what was the most important thing to you?
My safety.
What would you have done to protect that safety?
I can only say no on that.
And I'm going to ask, first of all, just a general question to those in the front row. Can you appreciate the difficulty of discussing the most intimate details in your lives? Mr. Hasel, that's not something you want to do, is it? Is that a no? Right. And ma'am, your name again? And Ms. Davis, that's not something you would like to do, right? Sir, your name? And why is that?
It's not.
Uncomfortable for you? Hard to talk to a complete stranger about it? When we're children, who's a school-aged child here other than you? Anyone else have a school-aged child in front of them? How old is your child, sir? Your name?
13, Sean Simmons.
13. And what have you taught your child about when it comes to adults?
That's all I for.
Respect adults,
Yes, sir.
right?
There's your toes.
Do as you're told. Anyone else? Have school-aged children in front row? Yes, ma'am. How old is your child?
6,
Okay.
9, 26.
Okay. What have you taught your children about adult figures?
They need respect.
What else?
That they need to, make sure that they're, the truth is a big deal to me.
And how do you know if your children are telling the truth as you raise them?
Just by being around them a lot, here.
Just using your common sense, your life experiences? And will you apply that to the same, to the witnesses who testify here in this trial? Now, hopefully you didn't have any problems with your children as they went through school, but if you did, what were some of those problems you might share? Any problem with grades or anything like that?
Yes, the my children are very active, and so they had many issues with school. My 6-year-old, she's already been having many problems with the school because of her behaviors.
Excuse me, counsel, you approach.
Yes, sir.
Okay, I'll give you a lot of leeway, but don't get too far afield. You know, when you ask me about opinions, but I don't need to know their whole life experiences or this really isn't voir dire. It's more of indoctrination. So let's get to questions and stick to the topics and let's move it along.
All right, Judge.
All right, may continue.
Ms. Hughes, now you indicated you already know something about this case because Joni and Angie are your cousins, is that right?
Yes, all of them.
And Paul is your aunt.
And bring them back to work.
And whose side of what version have you heard? They told you,
Not him personally.
I got you. Now, the question, can you set aside that information you already have and be fair and impartial in this case? You cannot. Now, we asked a lot of questions, but as you sit here in front of me, is there anything that I haven't asked you that you need to tell me to be important for your ability to be fair and impartial in this case? I'll start with the front row. Anything? Sir, go ahead. Your name again?
Mayor McCoy.
Yes, sir.
I know the defense attorney,
Okay, how do you know Mr. Hazen?
just probably in friends. Yeah, I don't know, just acquaintance.
Okay. When's the last time you saw Mr. Hazen?
I don't know, weird.
Can you set that, I won't call it relationship, in fact, you know, the defense attorney set that aside and be fair and impartial in this case? Anyone else? Anything else? Yes, sir.
Also, this attorney, family family.
Okay. How long have you known this family? How well do you know Mr. Hazen? Socialize with him? And you set that information aside and the fact that you know him and be fair and impartial in this case. You socialize with his family?
See him every now and then.
But that's not going to impact your ability to be fair and impartial. When you say see them now, every now and again, what do you mean?
North Town or at the dairy bar or the gas station or
You live here in West Cheney or
Winchester.
Winchester? Anyone else? No, thank you. 1 second, please.
All right. Counsel, when you're ready, I want to talk sidebar.
Yes, sir. All right, thank you. All right,
Do you have any other questions you
I
would
just
like?
have one final
All right,
question.
go ahead and ask it,
Thank
and then we'll talk.
I appreciate it. Thank you. So we talked about sex offenses. Anyone in the front row and the second row, I guess, have a close family member, and the folks already told me, I appreciate it, have a close family member that's been a victim of a sex offense. And your name for the record, sir?
Maurice Adams.
And who was that, sir?
That's that.
Okay. And when was that, sir?
Probably 20 years.
20 years ago. Was that person prosecuted? Do you know if it's a family member or not? When you set that aside, sir, and be fair and impartial in this case, I mean, you can go back and it could be difficult. Go back and look your spouse in the face and say, my verdict was whatever it is. You can do that based on the evidence and the laws the judge gives you. All right. Thank you, sir.
Okay. Counsel, you approach. Okay, unless you're gonna try to rehabilitate, excuse, Emily. 428. 428. Is there an objection to that?
No.
How about you, Mr. Thompson? Okay. And then, Mr. Yates, he said would take evidence to remove his preconception. I think that's his test.
Good. How about Mr. Dean, Your Honor, for, I'm sorry.
Any objection to that?
No objection.
Okay. And then Mr. Dean. He just was on this jury. He's
Right. He's not.
suitable, obviously, to be a juror in my estimation. Okay.
Thank you.
All right. Okay. All right, those are the ones that I have at this point. I'll excuse them now.
Okay. Thanks, Judge. Thank you, Your Honor.
All right, the state's completed voir dire. At this time, I'm going to make some excuses, and you can report to the clerk's office after I call your name. Mr. Dean, you're excused. Report to the clerk's office. Ms. Hughes, you're excused. And Mr. Yates. Thank you for coming in. All right, now, the defense will conduct its voir dire. Mr. Haslam.
Thank you. Good morning. Seems like I haven't had a chance to talk to anyone this morning. So first off, my name's Aaron Haslam. This is my client, Kevin Gaffin. And just as the state's honored to represent the state of Ohio, I'm honored to represent my client, Kevin Gaffin, this morning. So let's start with just some preliminary questions. First, because Mr. Wood brought this up, how many people in the room know who I am? Here. So let's concentrate on the first two rows. Is there anyone here that would have a problem listening to the evidence, hearing facts, rendering a decision that's fair based on the evidence? Knowing me, would that in any way sway your final decision of innocence or guilt? If so, let's see a hand now. No one? Who here knows Kevin Gaffin? I know we've asked this question, but I just want to follow up again. Did we miss anyone earlier?
Well, just to the first group here right now.
I just know the name throughout the affairs.
Anything that would cause you problems doing any decision in this case? How do you know?
I just, like I said, through the affairs where either derbies and things like that, I don't know it personally.
So you said do the fairs such as places like the Adams County Fair where they do a derby card,
Yes,
a demolition derby card competition? Ever compete against them?
not that I'm aware of.
Not that you're aware of. No hard feelings for them?
No, sir.
Anyone else know Mr. Gaffin from derby competitions? Anyone else socialized with Mr. Gaffin? What kind of socializing?
Just around with mutual friends.
Would you consider him a friend, acquaintance?
Someone I would see and talk to if I was out.
Any problem listening to the evidence and based on that rendering a guilty or not guilty verdict in this case? Based on the fact that you spent time with him? Anything between our relationship that would cause you a problem rendering a fair judgment in this case? So let me go through some of the witness lists here. See if one of them started. First off, I have quite a lengthy witness list, and I can tell you right now, I will not call all these witnesses. So I do have to ask the question, if I don't call all the witnesses, the names that you hear this morning, will you hold that against me or against the client? Is there anyone that would do that if I don't call every witness on this list? Okay, let's go through some of the names. Adam Pollock. Yes.
He graduated in my son.
How old are you now?
He also played baseball with my son. He graduated in 2012 and came over, please hang out.
Anything about Mr. Pollitt, if he's a witness in this case, that would cause you to not be able to render a fair and impartial verdict?
For the record, you're Miss Worley, right?
Now, Ms. Paul.
I'm sorry. Good thing I asked, Miss
Do
Paul.
you have your number?
Right.
Yes.
468.
Thank you.
Yeah.
Anita Harder. Braxton Gaffin. Let's start.
He also played baseball with my son, same hometown.
Same situation as the last Mr. Pollock. Same answer to the question, fair and impartial. And just for the record, may we have your name?
My name is Tina Paul.
And I'm sorry, Ms. Paul, I do know your name,
It's
we want to make,
P468.
we just want to make sure we keep the record clean. Thank you. Mr. Hazelbaker, how do you know Mr. Gaffin? Not this Mr. Gaffin.
Had nothing to do.
Okay, how many years? One. And you're a teacher at West Union High School, is that correct? And what class did you have in? And how many years ago was that? 8 years or so? Okay. Anything unusual, good relationship with him? I'm assuming that the student teacher, was he bad in class? Good student? Didn't cause you problems, nothing that would cause you to be upset if he testified? You could get those memories of some kid in the back row shooting spit wads at you. Fair and impartial? In this case, thank you. Braden Palmer. Brian Rao.
He's my supervisor for special education.
If I recall, you work with Manchester Local
Yes, I
School
do.
District, and he's an employee there. Good relationship?
Yes, because I work with him a lot because he goes to special education, so therefore I'm always having to work in preschool, so any child that I have to take care of, he's in charge of also.
I'm sorry? And that was through your work as in truancy and some other matters previously discussed? Any issues with Mr. Rao? Bryce Cook? Kara Roush? Carson McFarland? Chief Jeff Bowling?
Mr. Hazelbaker raised his hand.
And how do you know Carson? How long ago? Good student? Wasn't shooting you spit wads? Chief Jeff Bowling of the Manchester Police Department? Yes, Mr. Redwood.
Going in through the interview process, I sat on the interview board and did like the police department.
Okay. Did he ultimately get an offer?
He was not offered that position, but I was not offered that position.
Okay, that was the follow-up question, thank you. Chris Oliver?
Back row.
Yes. May I have your name?
Larry Newman,
Mr. Newman, how do you know Chris Oliver?
he's my wife's boss,
Okay, she works at the National Bank of Adams County. How long has she worked there?
20 years. I don't know exact age, but 20 years.
So, if you know, do you have any kind of relationship with Chris?
And I just, good friends, I, don't associate with him.
Does she appear to have a good relationship with him?
Yes.
Good work relationship? So nothing that would bias you or prejudice you in this case? Cindy Irwin? Dalton Schagner? Same situation as previously? Damon McLaughlin. David Shire. We'll start with Mr. Hitzberg.
I just know that Mr. Shire, living in small communities, I know who he is, I've spoken with him, so.
Would you consider him a friend?
Or
Acquaintance? When's the last time you socialized with him?
Been quite a while, more than a year.
More than a year? Same.
Yeah, I know him just, he's home office work, it's all those parts, for sure, it's David Shire,
Correct, would be from Links, Ohio.
Yeah.
Anything that would breed any kind of, well, okay. Just knowing him through that relationship, have you had any bad dealings? Anything that would cause you to be biased or prejudiced in this case? How about you, Mr. Speaker, can you be fair and impartial in regards to the driver? Can I have your name, ma'am, before me? And you said you know Mr. Shiner? And who's this is? Okay. Did you stay in contact with David Shiner? You talked to him at all last week? Has he talked to you about this case at all? No. Think you can be fair and impartial? Deputy Mike Eastep. Okay, let's start. Amanda.
Jill Palmer, who's our security officer during last semester.
Okay.
He's also treated him.
You treated him as a patient. Okay. He didn't arrest you when you were in high school or anything? Okay. Making sure. Good relationship with him, I assume? Professional, no problems? What's the next game?
I took care of his brother.
And how long ago? Based on your relationship, obviously taking care of a patient, you get to know the family very well. Is there anything that would lend you to give more credibility to him or other witnesses? Still be fair and impartial based on what you told us earlier today? Yes, sir. So you serve as a firefighter with Deputy Eastep?
He serves on the people, some of the students, yes, sir.
So how often do you interact with them?
Just occasionally.
So in my experience, firemen are like brethren, very close, even if you don't see them a lot. Would you lend him more credibility than other witnesses? Mr. Rabel?
To the sheriff's department, for the DSO, for this country, through my relationship with the sheriff's department.
Here in Adamstown. Okay, ask it, I think I know the answer, but what did you do prior to your current job?
I'm a retired police officer, spent 6.5 years working with highway patrol, spent 25 years with the sheriff's department in Hamilton County, and I currently do have a reserve officer commission with the Adamstown Sheriff's Department.
Mr. Slockheimer, did you raise your hand?
Yes, he was officer on our phone.
Okay. Any bad interactions with him in school? He didn't arrest you? Anyone else? Yes, sir.
Maurice Adams, I run with the Adams County EMS.
So I'm going to ask you the same question, because I know that's a tight knit group. Several of the individuals that you serve with. Anything that would cause you to have more credibility to Deputy Eastep and other witnesses? Was that relationship? Be fair and impartial? Mrs. Worley?
I've known him a long time, he grew up in Peoples. I just know him from the my squad, he's always fish fries, he's always working. I would just say, consider him.
Thank you. Did I miss anyone? First two rows? Gary McClellan. your entire life, probably knew his parents.
Yeah.
Anything that would cause you to lend him more credibility than someone else? Did I see anything?
Is that the hearing or is
It is, sorry. He owns Mosier Furniture, and I'm not sure if he still does, but at some point in time he referred to doing basketball games on C-103.
I do agree because we've done business with him and basically the people on a number of furniture and appliances and things like that.
So I'm assuming good dealings, same question. Can you be fair and impartial, not want to lend him more credibility than anyone else?
It's a business relationship with Gary, not socialize or anything like that.
Okay. Jason Cook. Jason Malott. Jeremy Kahn. Jimmy Vaughn. John Taylor.
John Taylor.
John Schneber. How long have you lived next to John?
John just purchased a house within the last 2 years.
Did you know him prior to that?
Yes. Because we grew up in the same hometown.
So you've known him
Yes.
probably your entire life or close to it?
Yes.
Okay. Any good dealings with him, bad dealings, or just an acquaintance?
Just, there's no dealings at all, just good neighbors. He works the same place where my husband works, so, that's all.
Thank you. Anyone else than John Taylor? Josie Winterhalter? Josie Francis?
Wait a minute, Mrs. Worley, Newer.
I'm sorry.
I serve on the library board for Jason.
How long have you served on the board?
I should remember, probably 6 or 7 years, I really don't remember for sure. And I knew Jason before that, she was special ed supervisor.
So you've known her for a while?
Yeah, I just got a friendship with her.
Okay, thank you. Anyone else? Anyone? Josie Francis?
I know Joe. My best friend, my daughter, Denise, is now deceased. So I graduated with Denise.
Same type of relationship as with John Taylor? Larry Heller?
He coached my son.
Okay.
I'll read one of the letters of insurance.
I saw another hand. Public figure. Okay. He's our clerk of courts, so if you recognize the name, that may be why. Leah Wilkins?
She's guidance counselor at Manchester.
You seem to know everything.
Sorry.
Maybe I should just talk to you first. Liam Wagner? Mark Ham? Oh, Mr. Swagam. How do you know? And what's your daughter's name? And that would have been approximately how many years ago?
11.
And do you still have any interactions with bringing up?
No, not really. I know she's in a good guard.
Do you have any interaction with Liam or her husband or the rest of the family? So it dates back the relationship 11 years or so.
Kelly Anderson and Jeremiah, and I know they're related.
Okay. Mr. Rabel? Oh, sorry, I didn't say your name. Did I see another name back there? Yes.
She's real good friends with my spouse.
Okay. When you say good friends, can you give me just a little more detail?
Well, they've been friends since high school. They haven't been quite as close as of late. I mean, as far as talking in the business school. Maybe once in a while.
So because they know each other well, do you know Liam well?
Yeah.
With that?
I've spoken with Liam's husband. He did several things. He told several times of job opportunities and things like that.
Anything about that relationship that would cause you to lend more credibility with what she may have to testify to? Be fair and impartial based on what you hear. Mark Hamler. Michael Decker. Paula Gaffin. start here.
I just worked with her for a short time.
That's right, you disclosed that earlier. Thank you. Where did you work?
Thomas Industries.
And that was, if I recall, down the bottom of the hill. Okay, how long did you work with her? You said short time.
Probably 15 months.
When you say work with her, did you guys work close together or she was in the same
I
building?
scheduled the department that she worked
Okay, so you were the scheduler?
in. Yes.
Did she ever get mad at you about scheduling? No, good relationship?
We didn't really talk. We knew of each other, but I couldn't talk to her on a daily basis.
Okay. Thank you. Going right to left, who's Mr. Razorback? Same thing, she and the defendant have children together, so you have the same questions you answer about as we frame and rest. Correct. Moving on down, Stella's on the other hand.
Denise's sister.
Okay.
Her sister was Denise, and Denise and I went to high school together and worked together.
Rob Bentley. So let's go left to right this time.
His wife is a friend.
How close? Okay, so you interact frequently, or at least periodically. Is it just in a social setting? Do you talk on the phone with her? Do you have a close relationship with her otherwise? I saw another hand. Start with you.
He is related to me somehow, not really only,
Good.
maybe right now, because I know you're related to me. He's having a hard relation, I don't know how.
Probably don't see him at family gatherings or other.
I know his wife.
Okay, how well do you know his wife?
Not well.
Don't interact periodically.
Just on Facebook.
Okay. Did you raise your hand?
Yeah, my wife's don't interact with him or anything like that.
Okay. Any other hands? Rodney Kersey. He owns RHK Motors. So, how many people here know him personally outside of purchasing a car from him? How many people have purchased a car from him? How many people had a bad experience purchasing that car from him? Roger Applegate? Yes, sir. Where did you work with him?
GE.
How many years ago?
9 years. Probably 2 years.
Do you recall approximately what his age is?
This is with Manchester.
Correct.
Okay, wait. 60.
Okay, so Roger Applegate Jr., I'm sorry for not clarifying that, I think you're probably talking about this one. So with that being said, he would be closer, I would say, in his 40s. Okay, sorry for not being more specific.
He's also married.
I know where I'm coming for cookouts. So he's your neighbor, how long's Roger been your neighbor?
They just moved from one end of the street to the other, and probably the last 3 months he's lived.
Do you have regular interaction with him?
Just now.
Has he talked to you about this case at all? Tara Applegate? Same answer you
Yeah.
were. She would be the wife of Roger Applegate. Does anyone else know Tara Applegate? Troy Wooler?
From the same hometown. Manchester Signal.
last name on my list is Tyler Andrew. He is an attorney at John Caldwell's office. Is anyone? Yes.
Tyler's not really a friend, but my daughter-in-law is in practice at the moment.
Has she, I do want to explore that just a little bit. Has she talked to you about this case at all?
No, she never discussed it.
Never discussed it?
Except I'm going to be late for other than that.
Is there any way the fact that he's a witness for the defense in this case, would that sway your opinion on the facts and evidence you're going to hear?
I really don't know Tyler, other than to recognize him and say something.
So you can be fair and impartial.
I think so. So the court has previously stated, it's been a while here, so I do want to restate it, I don't want to repeat a lot. But the fact that the defendant sits here right now is not evidence of his guilt. Can everyone accept that? That he's innocent until proven guilty? The state has told you that, they've said they welcome the burden, and we're going to put the burden on them, because that's what the Constitution says, that's what the law says, that's what the judge is going to instruct you. So the fact that he's been accused does not mean he's guilty. Can everyone accept that premise? Has everyone heard of the right not to testify? Watching crime shows, has anyone not heard of that? So the defendant may choose or may choose not to testify in this case. The judge is going to instruct you that that's his right. Can everyone accept that premise? That the burden's not on him to defend himself. The burden's on the state to prove each and every element of the crime. And if they don't do that, he and I, we can sit here this entire week, not say another word, and if they don't meet their burden, you have to return a not guilty verdict. Can you accept that premise? And what I'm going to tell you is we're not going to do that. You're going to hear from me quite a bit, but we don't have to. And can everyone here accept that? So let's talk about reasonable doubt. And this is going to be the instruction you're going to get from the judge later in the week about what reasonable doubt is. So I want to read it to you so I don't misspeak or paraphrase.
Excuse me, Mr. Haslam, I don't permit the lawyers to read the law on board. You can talk about the issue, but the court will be the one that will instruct the jury in the appropriate time.
Okay, well, let's get back to the state's, thank you, Your Honor. Let's talk about the state's flag, when they pointed out the flag earlier. So that flag, and I'm going to, is it Mrs. Baumgartner? I think they asked you multiple questions about that flag. So when you look at that flag, you think it's the American flag, correct? Do you believe that it's the American flag just because these two gentlemen here tell you it's the American flag? Because if we opened it up, it might not be the American flag, is that correct? So as you sit there, their word alone is not enough for conviction. Is that correct? Do you want them to present evidence to you, establishing that that's the American flag?
Probably.
Before you can, beyond a reasonable doubt, say that that's the American flag, would you want them to at least send one somewhere there to open it up? No. You're being honest. That's what we're here for. So, what would convince you that that's the American flag? Do you just accept my word for it or their word for it?
No, I see it, and so I don't have full, it's not full, but I love my own self, and I say, you all that, I say, that's great.
What if I opened it up and only had 20 stars? Would you say that it's the American
It's
flag?
the old one.
about you, Mr. Rabel? Would you just accept her statement that that's the American flag?
Yes, sir.
What would you want?
There has to be some other evidence to go along with it.
And what type of evidence is that?
This is super that seen the flag over the backwards. General crime, there was not observations.
Maybe even an expert on American flags? I don't know, I'm sure they exist somewhere. So you wouldn't just accept their word or my word that that's the American flag? Can we approach you on?
May.
You know, just indicate that nothing we say is evidence. I
Right,
don't want to
and
confuse the jury.
I'm
so
going to make
it's-
a comment on that. So you mean to say the evidence they present?
Yes.
Just to clear something up, ladies and gentlemen, statements by counsel are not evidence, and none of what's occurring here now is evidence, but it's basically trying to ask questions about your processes. So phrase it in that term, Mr. Haslam.
Yes, sir. Mr. Did I understand you were in a car accident recently? How long ago? When you say a couple years ago, 2 years ago, 3 years ago? Do you recall the year?
16, so be 14.
So it was in 2014? Was there a police report?
Yes.
So I think earlier you stated that, there's certain, or we heard that there, sometimes you don't hear all of the, or you don't remember all the facts or recall the facts?
Right.
But when the police report generated, help you recall those facts?
Yes, and
And have an opportunity to review it? How about you, Ms. Gardner? I know we talked about a car accident you were in 20 years ago? Do you recall what year? Where did that accident occur? Milford, Ohio? Okay, and that's Hamilton County, I believe. Claremont, so it was in Claremont County, okay. Was there an accident report? So if you have an opportunity to review the accident report that was, I'm assuming, done by the police department, you will be able to recall some of the facts of what occurred, such as the caller, the caller, the person that was involved in the accident review, those things. I'm assuming that that police report was part of the accident investigation done by the police department in that area? Did they? Yes.
Yeah.
Ask you questions, took down your answers, put it into a report, and so that report's there to assist you in the future. Mrs. Worley, I believe you stated earlier that you served on juries.
Yes, and I forgot, I also did federal jury service.
When did you do federal jury?
Oh, gosh, my husband died, I think it was from 2011, something like that.
What kind of case?
I just remember the guy leaped over a fence, it was stealing, I don't know why we were there, but I was protector.
And what was the result?
We found him, that police officer, run away from this police officer, that's all I remember.
And then you served as an alternate on federal jury. And you said that was a not guilty finding?
There was a not guilty finding, but I was alternate, I didn't have to decide, and it was a personal assault. Out in the cemetery, which was very long ago. I can remember the names, but I don't want to say the names.
No, that's okay. Thank you. So, Mr. Dick,
Yes,
am I pronouncing that correctly?
yes, HIP2.
You said you enjoyed grand jury. What did you enjoy about grand jury?
Just the process of
enjoyed it as much as the process going through the jury, honestly, and so I was just a little confused. You said that you were 3 from getting into the jury box.
I was third one in line.
Did you actually make it into the jury box?
Yes, I did.
And then
The prosecutor asked me some questions, and he turned it over to defense, and defense dismissed it.
Sorry, too many notes. So we talked a little bit about post-traumatic stress syndrome. I'm going to start with Mrs. Baumgartner. You said that you were a psychotherapist. Can you tell me what that is? And what kind of training did you have to receive to become a psychotherapist? And you've been retired 10 years, did I hear that correctly? Have you practiced at all during that retirement? No. Are you still licensed?
I am not. I had one for practice, number my LIS 2 years ago.
Because you weren't doing it. So, obviously, if you let your license go, your training's not up to speed, or have you stayed up to speed with your training and education? No. So if there's an expert that testifies in this matter, will your prior experience in any way influence your decision-making or the expert witness's credibility?
I think I could be, my judgment is clear. I don't have prejudice.
Yeah.
I do want to say something, because I had a psychotherapist, and I think this relates to this case. For probably 15 years, I ran a weekly group at the mental health, 2 different mental health clinics, for men who sexually abused children. I also have worked with children and mothers, families, children that were sexually abused. So I don't think that would, I think I can have a fair judgment.
Front row here, Mr. Haslam.
Yes.
I also want to let them be known that Tyler Cantrell, I know him because I think that he's related to my husband, like second cousin, something like that, but
Nothing beyond knowing who's
Nothing.
related to,
Right.
no interaction with him, he doesn't represent you in any
no,
matters.
nothing like that.
Have you seen him at any formal functions?
No, but he did, for a short while, coach my son's soccer team, but, then somebody else ended up coaching because his wife was pregnant and, they had to stop with that, so.
How long did you coach your soccer team, your son's soccer team?
It wasn't for the full season.
How old was your son when you coached the soccer team?
My son is 3 and,
So, young age?
yes.
But you're still in.
yeah.
No arguments over playing time.
This, as far as Tyler Cantrell, that was from college, and they used to be
For employee logging. Do you interact with him frequently? Anything that would cause you to have more credibility to him and other witnesses? Hear the evidence, the testimony, and other matters of community or impartial work. Mr. Grooms, I believe you stated that your father was a Vietnam vet and he suffered from post-traumatic stress syndrome. Was that diagnosed?
Yes.
And how many years did he suffer again with that?
He served for 22 years in service only, and so when he got out, he had seen a psychiatrist, not regularly, but in his later years, he's seen a psychiatrist on a monthly basis.
What kinds of experiences did you have when you were suffering from post-traumatic stress syndrome?
He really hit it very well. He functioned pretty good until his later years. He was more, had a lot of road rage, and he could be around people when he was in his later years. So that's what he more when he was older.
And I'm assuming that was hard on you and the rest of the family.
Yes. I went to a few of his sessions and helped him out. He was also disabled because of some issues that happened while he was in service.
Any lingering feelings that you may have that may cause you problems with serving on this jury if there's an expert that says someone's suffering from post-traumatic stress syndrome?
Facts.
Thank you. Ms. Baker? I think you stated previously that your husband was a Vietnam veteran and he suffered from post-traumatic stress syndrome? Still does. And you had a father that also suffered from it. Was he also a veteran? Yes. What war? World War II. And they both suffered, so you've had a lot of experience with post-traumatic stress syndrome. Thank you for both your husband and your father's service. Any lingering feelings of currently dealing with post-traumatic stress syndrome with your husband or what you dealt with your father in the past that would cause you to not be fair and impartial in this case? You mentioned some of the symptoms when you spoke earlier: depression, anger, addiction, isolation. What kind of addiction?
Well, for my father, it's alcohol. My dad died from his death.
What kind of convulsions?
We have to go purchase something 24 hours. Like different things like cars and things like that. He sees one. It's like, get out, it's waiting 24 hours to think about it. It's 24 hours. Talk about it. structured environment pretty well. Okay, so it just gets out of kilter with really good. This one told hell, get angry. So we learned to deal with that. I spent a lot of time with him and his counselors because he would not cooperate unless I was
And in your, so you participated in counseling with him? And under counseling, he seems to function much better?
Counsel, would you approach? How much longer?
5 minutes.
5 minutes, okay. Well, let's move along and get to the same point they are, so I'm talking about things other than rules, so let's move on. All right, you may continue.
Thank you, Mr. Baker. Yeah, one moment.
Yes, go ahead.
So just one last thing, I do want to apologize because I know many of you know me, many of you know my client. And if we didn't have an opportunity to speak to you earlier today, because we're not allowed to speak to the jury, and that's going to occur throughout this week. So I don't want you to think that we're rude or hold it against either my clients or one. With that, I have no further questions, Your Honor.
All right. Counsel, would you approach? And ladies and gentlemen, we're going to discuss some jury selection matters here for a couple of minutes, so bear with us.
Oh, I'm sorry. Get out of here. Come over here. Oh, I thought you were.
Okay. Any further challenges for cause?
Not from the state, Your Honor. No, not for cause. Not for cause.
All right. Well, then, what we're going to do, I'm going to write this down in my chart so I can keep track of it. And so that means juror number 1 will be Mrs. Grooms. Juror number 2 will be Ronald Hastings. Juror number 3 would be Sharon Davis. Juror number 4 would be Richard Griffith. Juror number 5 would be Patricia Pfeiffer.
Who did you have for number 5?
Patricia Pfeiffer. If I'm skipping over anything, but
That's what I had.
okay. Yeah, feel free to correct me, counsel. Well, I'm wrong. All right, juror number 6 will be Sean Simmers. All right, and then we're going to number 7. Lear McCoy. Love that name. Juror number 8 will be Tandra Matthews. Juror number 9 would be Aaron Schweiker. Juror number 10 would be Sandra Young. Juror number 11 would be Rebecca Kirker. And juror number 12 would be Robert Pitt. Everybody agree with that?
Yes, Your Honor.
Okay. Mr. Haslam?
Yes, Your Honor.
Okay. All right. So that's the first 12. All right, now, the state and the defense will each be entitled to peremptories. So, 4 peremptories each. So we'll start with the state, and you can exercise peremptory against the 12 that are in the box.
Yes, sir. State would thank and excuse number 4, Richard Griffith, who is juror number 416.
Okay. And I'm not going to identify who's speaking.
Just number 4.
So, yeah, but Griffith, okay.
Okay.
So then, striking out Mr. Griffith, that would move into his spot, Larry Goodman. In seat number 4. All right, Mr. Haslam, on behalf of the defendant.
We would thank and excuse juror number 1.
That would be Mrs.
Karen.
Griffith. All right, so then from there would move Roger Fetters. All right, Mr. Miller.
Your Honor, juror number 6, Sean Simmers.
Simmers. All right, and then that would move into there Jill Lammers in number 6. All right, defense.
Just one moment, Your Honor.
It's fine. If any time you want to talk to your client, you can do so. Talk to him. Just stand by. Ladies and gentlemen, we'll be through here in just a few minutes and we'll have a jury. And so that's why I'm keeping you past the normal time so that you don't have to come back after lunch. So we'll be winding up in about 5 to 10 minutes. Oh, I'm sorry. I'll bet they heard me. Everybody, we're going to excuse you here in about 10 minutes. So.
I think you're done. You want the white noise off? You finished?
Yeah, go ahead and put the white noise off. I usually don't have a trouble getting softer in my old age. We will be completed here in just a few minutes, and so I'm keeping you a little bit later than normal because that way those of you who aren't selected aren't going to have to come back again. And those of you who are selected will know your fates. So we'll be finished here in just about 5 or 6 minutes. Now you can put it back on. Yeah, sorry about that. I forgot about it a little bit.
I think they do.
You have additional peremptory, Mr. Hayes?
We would thank and excuse juror number 8, Tandra Matthews.
All right, and then into that seat would move Ruth Ann Moore. All right, the state has 2 left.
Yes, sir. Number 7, Leroy McCoy, Your Honor.
McCoy. Okay. And then into that would step Rita Blue, I guess. Is it blue or blue? Blue, I think. All right, the defense has 2 left.
thank and excuse juror number 12,
Blue.
Robert Hill.
Oh, I'm sorry. Yeah, that would be 12 in my court. Number 12, Mr. Hitt. Robert Hitt? Okay. All right, then that would bring up Rosalie Barrett. All right, and the state has one remaining challenge.
Your Honor, number 9, Aaron Swackhammer.
I would move into his position, Mary Jo Catherine Baumgartner at number 9.
Who did you have that putting into?
For number 9 it'd be Miss Baumgartner. Okay, you have one parameter left, Mr. Haslam.
We would thank and excuse Ms. Baumgartner.
Okay. Then that would move into that seat, Carol Baker. Okay, that will complete the jury. Now, I think I'll go ahead and see 3 alternates since it's a lengthy trial, and we would each have up to 2 alternates, or up to 2 challenges. And what I'll do is I'll let you preempt any of those that are in line. So let's see here. According to my Ms. Baker, the last one at the end of the box. So we've got 12 here. Yeah. Right. Then we'll have number 1 would be Mr. Gordon, 2 Mr. Raybold, 3 Mr. Hazelbaker, 4 Mr. Adams, 5 Miss Worley, and 6 Miss Hall. And in 7 would be Miss Nias. All right, so the first 6 we just have, since we're going to have 2 peremptories each, actually that would give us 7. So if we have 4 peremptories, that will give us 3. So you can exercise a peremptory against any of those. Okay.
Judge, can you give me that list again? I'm sorry.
Okay, the order?
Yep. Yes, sir.
Okay. Francis Gordon, number 461.
Mm-hmm.
Donald Raybold.
Okay.
James, it goes by Brian Hazelbaker. Maurice Adams. Linda Worley. Tina Paul. Brenton Niels.
Okay.
That would be the last 7 we have, and so we have up to 4 challenges total. So you can challenge any of those 7.
No challenges, Your Honor. Pass.
Okay. Mr. Haslam? That would leave us then with alternates being the first one Francis, second one Raybold, the third one Hazelwood.
We would thank and excuse Mr. Raybold.
Okay. All right. And then you would have 1 that you could still exercise, Mr. Miller, if you wish to do that.
Pass, Your Honor.
Pass. Okay, Mr. Haslam?
We would thank and excuse Mr. Brian Hazelbaker.
Okay. So, Hazelbaker excused, and Raybold excused. All right, so then that would leave us with the first alternate, Francis. The second alternate would be Maurice Adams. And the third alternate would be Linda Worley. Okay. And that's the jury. All right. Thank you. Have a seat then. Get the white noise off. Okay. All right, ladies and gentlemen, we completed the selection of the jury. As I read your names, and I'll be referring to you by the number that you'll be seated in the jury box, as opposed to the number you have on your tag. And the first, I don't know if we have some bailiff or someone that can help guide them to the right place. The back row will be juror number 1 through 6, seats number 1 through 6. The front row will be seats 7 through 12. And then I'm going to see 3 alternates will be seated in the 3 boxes just outside, 3 chairs just outside the box. And alternates will be present for the entire testimony and instructions, but will not deliberate unless there should be a need to excuse one of the first 12 for some unforeseen reason, which I've been in trials where we lost 2 in one day before trial started, so that's why I'm seating 3. So as I read your name, if you would please come forward, be seated in the number that I've identified. Juror number 1, Roger Fetters. Number 2, Ronald Haslett. Number 3, Sharon Davis. Number 4, Larry Newman. Number 5, Patricia Crawford. Number 6, Jill Lammers. Did I get that correct, Lammers? Lammers, okay. Number 7, Rita Ballou. Number 8, Ruth Ann Moore. Number 9, Carol Baker. Number 10, Sandra Young. Number 11, Rebecca Kirker. Number 12, Rosalie Barrett. And then the first alternate is Gordon Francis. Second is Maurice Adams. And the third will be Linda Worley. All right, and the deputy clerk now will administer the oath to the jury.
Please stand.
Yes, just a minute.
I apologize, this did not register when I was going through the jury list, and I know I asked if anyone knew me. I am currently representing a Stephanie Moore in a divorce case against Jason Moore, and her mother is on the front row.
Okay.
There's it. Judge, my only argument be,
Yeah, maybe we're going to waive everything. I mean,
Peremptory
see, but that's an issue here. Yeah, you didn't inquire into it, so it's not a matter of record.
I didn't see her position back there. When she was walking, I recognized her.
She's not a party to the action, right?
Right. Well, yes and no. I mean, grandparents have rights, and
Well, she's not involved in litigation, is she?
other than a witness, no.
She is a witness.
Yeah.
Do you have a trial date set yet, or
No trial date set.
she may not know about that?
Well, I think I do have a duty to inquire. Be seated, please, folks. Wait a minute, you stay right here, counsel. Number 8. Ruth Ann Moore.
Yes.
Okay. Ms. Moore, number 8. Just add a last one. Stay up here, counsel. To attention at the last minute was overlooked, but is your daughter a party to an action which Mr. Haslam is representing another person?
My son and daughter-in-law are divorcing.
I know. Have you had any involvement in that, or are you?
So far, haven't.
Okay.
I have the children at home right now.
Well, the question I would ask then is that would that influence your decision in any way, or your ability to be a fair and impartial juror in this case?
I'd rather be excused from
All right. That will excuse you then. So you can go ahead and check out. So that means that Mr.
Wait, you want white noise?
Yes, go ahead. All right, I'll move Mr. Francis into that spot then. All right, so Mr. Francis, you've been promoted. You go into seat number 8. Okay, and then that means so. All right, then, Mr. Adams, you'll become alternate number 1. This Worley becomes Ms. Worley, you'll become alternate number 2.
Get your attention just a second.
And let's see, that means that, okay. That would move Miss Paul then into the third alternate position. Okay. And Miss Paul would then become the third alternate. So everybody waived that challenge, so I'm going to seat her then as number 3. All right, so Tina Paul, you'll become alternate number 3. Okay, thank you, gentlemen.
Thank you.
Okay, now we'll have the deputy clerk administer the oath to the jury.
Do you solemnly swear that you will diligently inquire into and carefully deliberate all matters between the state of Ohio and the defendant, Kevin Gaffin, and that you will do this to the best of your skill and understanding without bias or prejudice, so help you God? Thank you.
All right, thank you. All right, we're going to adjourn here in just a recess, I should say, in just a minute. Ladies and gentlemen of the jury, I will instruct you, remind you earlier of the instructions. You'll continue to follow those during the lunch recess, and I'll have more thorough instructions after lunch. But during the recess, you're not to discuss the matter with anyone. You're not permitted to allow anyone to discuss it with you. That includes even among each other if you should happen to be together for lunch or get together before we resume court. You're not to read anything about the case. Typically nowadays we have to worry about the internet because sometimes news is on the internet almost as it happens or as people think it happens. And so you're not to read anything about that or to try to gain any information about the case during the recess. And that means not reading any articles about anything or talking about any of the people whose names you've heard or anything of that matter. If there should be any instance of that, if somebody's talking about it, then you need to tell them, I'm a juror, please don't discuss that. If they insist on talking, you'll need to leave from wherever the conversation is taking place. Now, from now on, when you report back, we'll want you to report to the jury room, which is right over there. And we're going to break now. I have about 25 till 12:35, so I'm going to ask that you come back at 1:45. That's a little more than an hour for lunch. You may go anywhere you want, as long as you're back on time. We would like to resume court at 1:45, so if you can be back a few minutes early, that would be appreciated. Now, for the remainder of the panel, you probably wonder why we had so many people here. I always exercise caution. It's better to have too many and not need them than have not enough and need them. And I've been there and done that and sent the sheriff out to find people, and I don't like to do that, and people don't like to be really drafted then and brought in as talesmen. So your presence here today has not been in vain. It has been, it certainly made me feel more at ease. I don't know about anybody else, but it made me feel more at ease. But you are excused today. I'll just instruct you that you're not to try to talk to any of these folks that have been selected if you know them. Other than that, you're free to discuss it with anybody that you wish. And so, do they need to report to the clerk's office then? All right, if you would go through that door and report to the clerk's office, and then after all of you are excused, we'll let the jurors follow. Okay, then, ladies and gentlemen, that was during the recess, and report back no later than 1:45 to the jury room. Thank you. Thank you. Be seated, please.
Judge, I apologize. I just realized that I don't have the connection to put this on the overhead.
All right, well, I was going to bring that up, so on the record here. You want to do an overhead, and what is it you wish to do? Because my general policy is not to permit items that are evidence that are going to be offered as evidence unless there's no objection to them being admitted.
There's no evidence, Judge. It's a PowerPoint summary of my...
Okay, that'll be fine, then, as long as it doesn't include any evidence.
No evidence. I mean,
Okay.
other than just the name of maybe a witness here.
That's fine. You say you have it set up, or you don't?
I have everything set up, but the one cord that I presume that I'll have to set up to put it on television sets, I don't have.
So, somebody have one?
Laptop with them to your,
Yeah. It's a normal.
On the Elmer?
It's,
Is that an Elmo or?
yeah, that's the connection. Away from home. It doesn't, I don't have that.
I don't know if there's one. Oh, here's one here.
I assume this is a monitor for me to view what's being recorded.
Yes.
All right, no, I just see it as, I'm going to see it live.
You
so I don't
will
need to
see
do
it
that.
because it will go.
Oh, it is going to
back.
come on? Okay,
Once she goes on.
okay, I didn't realize. I don't care, I'm trying not to be distracted by it.
Is it all right if I go off record?
Yes, do pause while they're dealing with the technical issue. Okay. All right, we're back on record after the lunch recess, and is council ready to proceed?
Yes, Your Honor.
State? Mr. Haslem?
Yes, sir.
All right. Then bring in the jury. It's my understanding you are going to reserve your opening statement?
Correct, Your Honor.
All right.
Just one preliminary matter, Judge.
Oh, okay.
I don't know if there's any witnesses in here, but we would make a motion to separate if there are any witnesses.
All right, that motion be granted. Any persons in the courtroom that expect to testify are to be outside the courtroom doing that testimony. I'll leave it up to the parties to police their own witnesses. All right, then bring in the jury, please. All right, thank you. Jury is, you can be seated, thank you. The jury has now returned to the courtroom. Now, remind everybody to turn off any cell phones or electronic devices that you may have. Now, ladies and gentlemen, jury service may be strange to some of you, so an explanation is in order. Those who participate in a trial must do so in accordance with established rules. That's true of the witnesses, the lawyers, and the judge, as well as you. The lawyers present the evidence according to the rules. The judge enforces those rules and determines what evidence may be admitted. Now, you will be the sole judges of the facts, the credibility of the witnesses, and the weight to be given to the testimony that is admitted. And at the conclusion of the case, or evidence, the court will instruct you regarding the laws on these matters, and you will apply that law to the facts. It is your sworn duty to accept the law as given to you by the court. You're not permitted to substitute your own opinion of what you think the law is or what it ought to be. Now, the procedure in this trial will be as follows. First, the state's representative will outline what they expect the evidence will be. That's called an opening statement. And then the state will present its evidence, and then after that, the defendant will present his opening statement and then his evidence. Now, the opening statements of the attorneys are not evidence, and they are not to be considered as that. Rather, they are simply their prediction, if you will, of what they think the evidence will be, and they're designed to help you follow that evidence as it is admitted, if it is admitted, during the trial. Now, after the defendant has presented his case, and again I would go back to this, the defendant will present his opening statement. The defendant is not required to present evidence, so he may, but he's not required to present evidence in his own defense. If the defendant does present evidence in his own defense, then the state may, but is not required, to produce what's called rebuttal evidence, which is limited to rebutting evidence that was admitted during the defendant's case. Now, once that is complete, the court will give preliminary instructions on the law that is applicable to this case. Then there will be closing arguments of counsel, and then there will be instructions of law by the court of deliberations, and then you will deliberate. And I'll also tell you now, and I'll tell you again later, that the closing arguments of the attorneys are not evidence either. Now, the procedure for questioning witnesses will be as follows. First, the party that called the witness will ask questions. That's called the direct examination. After the party that called the witness is done asking questions, then the opposing party is allowed to ask questions. That's called cross-examination. And then after the cross-examination is completed, then the party that called the witness may, but is not required to ask additional questions. That's called redirect examination. And that would be limited to bringing up matters that were raised on the cross-examination. And then that will complete the examination of the witness. In case someone would ask, I haven't had it asked periodically, jurors are not permitted to ask questions. Now, during the trial, it's likely attorneys will make objections. Now, this is a procedure by which the attorney raises a legal issue that must be decided by the judge. And I don't make these rules up as I go. I'm bound by the law, just as you are, and I am required to follow the revised code that's been enacted by the legislature, as well as the rules regarding evidence and criminal procedure and other rules adopted by the Supreme Court. When an objection is made, I will determine then whether the question and or the expected answer is proper. And if I determine that either are not proper, then I will sustain the objection. What that means is then that the question and or the answer can't come in. Now, if I say overruled, then I've determined that both are permitted, and you will hear that testimony. Now, sometimes a witness will give an answer, and then an objection will be made in the middle of the answer or before the witness is saying, giving an answer before the attorney can make the objection. If I determine, if that occurs, and I determine that either the question or the answer or both were not proper, and I sustain the objection, I may tell you, or I try to remember to tell you, but I'll tell you also at the end of the case, is that you're to disregard that testimony or is to be stricken. So what that means is it's not part of the record upon which you can discuss the case when you deliberate, so that you will decide the case only on that evidence that has not been stricken. Now, it is important that you be fair and attentive during the trial. As I've already told you, you're not to discuss the matter among yourselves with anyone else at any time during any of the recesses. If you are a person who is active on social media, or you text, or you do any kind of entries on social media, you're not to post anything about the case during your jury service. So don't want you to go on and say, well, I'm serving on a jury and it's about this and that. You're not to do that. And the purpose of that is to try to prevent someone from texting you back or tweeting you back or some other reply on Facebook or whatever other social media sites you might be involved in that might say something about the case that you didn't intend to happen, but it might. So as to protect you from having that. Because as I've indicated, again, you're not permitted to have information outside of the record in this case. And you must explain the rule that you cannot discuss this matter with anyone during the trial proceedings with any persons that you come in contact with that may ask you about it. Now, once your service is over and the case has been decided, then you are released from this instruction and are permitted to discuss it. But during the trial, you're not permitted to discuss it. And since this case will go at least 3 days, you're going to have evening recesses and overnights, and you'll need to explain to your family members or those you come in contact with that you cannot discuss it. Now, sometimes people's memories fade, and they'll say, well, I was on a jury and I was allowed to talk about it. Well, if they followed the instructions of the judge in that case, and I'm sure they did, They've just forgotten that that applied after the case was complete, not during it. Again, once the case is complete, you'll be released from that obligation. Now, you are not to investigate or attempt to obtain any type of information on this case outside of the courtroom. It's highly improper for you to do that. So that means you can't do things like going intentionally to any of the locations that might be mentioned in the testimony to take a look at them to try to familiarize yourself with them. You're not permitted to do that. You're not permitted to research the matter. And so, we had a number of topics that were discussed this morning, and people may say, well, I'd like to know more about that. You're not permitted to discuss it, or to research those things while this trial is in progress. So you can't go onto the internet and look, which we all know has everything that ever needed to be known by us. It's always right. Well, not really. But you're not permitted to do that. You're not to read any articles about it. Not to ask anybody any questions about that topic. Now, once the case is done, then you can do the research as much as you wish. But in order for you to comply with your obligation as jurors, you're not to do that because it would be improper. You would be basing your decision upon information that you learn outside of the witness stand and the exhibits that may be admitted. Now, you're not to read or view or listen to any type of report about this case in any platform. So that would mean printed newspapers, internet, whether it be on a newspaper site or a radio or TV site, which I don't know that we'll get that, but those folks also maintain news sites. On any social media sites, you're not to read anything about that or permit anybody to read anything about it to you. You're not to listen to any radio reports, if there are any, or television reports. And again, you're not to permit anyone to talk about it in your presence. Because if you do, again, if you can base your decision on that, then you would be in violation of your obligations. Now, in the event that something should happen, occasionally things do happen that are not intended, don't ask the advice of your fellow jurors on what you ought to do. Report it to one of the court personnel. They'll report it to me, and then I'll consult with the attorneys to determine what action, if any, might be taken. And the reason I tell you not to talk with each other is this. Sometimes it's necessary to ask a juror when something like that happens, what was it that was that happened or was said, and find out what impact that has, if any. And if you were to go back to the jury room and say, folks, here's what came up, what do you guys think I ought to do? Well, then we'd have to ask all of you those questions, and I've been there, done that, and it takes a lot of time out of the trial. So, it also poses a whole lot of other legal matters that the court then would have to deal with the parties. So if you have a question in your mind, just err on the side of caution. Tell one of the court personnel, they'll bring it to me, and then I'll, like I said, I'll consult with the attorneys, and I'll decide what needs to be done, if anything. Now, the court doesn't permit note-taking on this type of case because I feel that it distracts sometimes from people paying attention. I know sometimes it's hard for me to write and to listen at the same time, and the most important part is that you all listen, pay attention to what's being testified to, what exhibits are being admitted. Now, as from time to time, we will have bench conferences, and you've already seen it, and you'll hear the white noise, which is to keep from going through the loudspeakers. And those conferences will potentially be perhaps about an objection or discussion of a legal matter that I have to decide. And it's not to keep you from hearing something you ought to hear, but from hearing something you may not be able to hear. So if there's an objection and I need detailed information from the attorneys that wish to present their opposing views, and they talk about here's what's going to be said and this and that, if I determine that that's not proper and can't be in evidence, and I allow that to happen in front of you, then that'd be more information that you would be told to disregard. Because any information that has been stricken, you're to set it aside. And we know you're not going to forget it because we're humans, we're not computers. But the way it works is that if I strike that testimony and you're in the jury room and somebody says, well, remember this was said, well, if that was stricken testimony, then as a group you're to say, no, we can't rely upon that because that was information that was stricken. And so by doing these types of things at the bench and out of the hearing the jury, trying to reduce that burden on you so that you don't have a whole lot of information that you have to remember to not consider. All right, now, as far as scheduling, I know some of you have been concerned about that, and I mentioned it earlier, but I'll repeat it, that as a general rule, we'll go about an hour and 15 minutes to an hour and a half. We will go till somewhere between 4 and 4:30 today, although it could be later. My preference is that, and I usually consult with the attorneys about this, is I don't like to stop in the middle of a witness's testimony, like before one side's done questioning them, or even overnight. I like to get it all in one time, just out of fairness to everybody. And so that's the general procedure. So sometimes we may stop at 3:50, sometimes it may go to 4:45 or even 5 o'clock, depending upon where we're at. The whole goal being to, if possible, reduce the number of days you have to be here, not the time, because the time will be put in. There's no limit by me on the parties as to how long they can present their case. There's no artificial time limits, but in terms of, keeping the matter moving and trying to get in a full day, if we can do that and save you a day at the end of the trial, then, hopefully you'll be appreciative of that, and it would help, expedite matters. But again, we'll take as much time as we need to get the case tried and, let everyone have their opportunity to present their case. But that'll be generally the rule we'll follow. You'll be resuming at 8:30 in the morning. That means I want to start back up at 8:30, so we'd like you to be here by 5 minutes before that or so and report to the jury room. And then generally we'll break for lunch about noon. That's the way my stomach's trained. It was reminding me of that today, but but not precisely. Sometimes we might break at 11:30. Sometimes we may not break till 12:30, like today, or a little later. So it just depends on where we are in the case, because I try to keep things so that we don't have interruptions and the flow of the case keeps moving and accommodates witnesses as well. All right, now, is there anything else from council before we proceed?
No, Your Honor. No, Your Honor.
All right, then we will hear the opening statement from the state. Mr. O'Reilly.
May it please the court, counsel, ladies and gentlemen of the jury, as Mr. Miller told you at the beginning of this case, my name is Scott O'Reilly. This is now the most important week of Ryan Applegate's young life. And I will tell you that you people in this room are now the most important people in that process, because it will be your job to determine the facts, the actual evidence in this case. You're going to hear testimony. You're going to see exhibits. It will be your job to determine the actual facts. You saw in the voir dire process, there's a lot of people who have connections in this case. I wasn't born in Adams County. I wasn't born in Brown County. And although I work in Claremont County, I actually live in Hamilton County. But the beauty of a courtroom, and what's so important about where you are, is that it's your job to determine the truth, the facts, the evidence. It's not the connections that we have. It's what you're going to hear and see in this case. And I submit to you, ladies and gentlemen, this is a case about a young boy who had to suffer. He had to suffer in secret and in silence for years. Ryan Applegate was born September of 2001. And you're going to hear him talk about his interactions with that man. And when that man came into his life from his marriage and relationship with Ryan's mother. You're going to hear in 2008, Ryan's young life would change forever when that silence and that suffering began. The defendant is charged with seven distinct counts: rape, sexual battery, and felonious assault. You're going to hear testimony in this case that counts 1, 2, 3, and 4, 2 counts of rape and 2 counts of sexual battery, relate to acts that took place in a barn at Ryan's home, perpetuated by the defendant. You're going to hear that those were separate and distinct acts of oral sex, or fellatio, and anal sex. You're going to hear about 6 months later from Ryan himself that another incident occurred, this time inside the residence, inside the living room, inside his home where he's going to tell you that, once again, the defendant inserted his penis into the anus of that little boy. And finally, with respect to count 7, you're going to hear, Mr. Miller referenced this, you're going to hear some terminology about post-traumatic stress disorder. That is going to be very relevant in this case. You're going to hear from experts that are going to talk about that. But again, and importantly, you're going to hear from Ryan himself and his family members who saw things, little hints at a secret that Ryan was keeping. Counts 1, 3, and 5 require that the state show that the defendant engaged in sexual conduct with another, not the spouse of the offender, and the other person in this case, because when these incidents occurred, the evidence is going to show you that it happened when he was under 10. Sexual conduct, and I highlighted those 2 individual points to highlight that we'll have to illustrate anal intercourse and fellatio, or oral sex. Counts 2, 4, and 6 relate to sexual battery. These are companion charges with the rape. But again, we must show that the defendant engaged in that sexual conduct. And again, the evidence is going to show, ladies and gentlemen, 1 act of anal sex inside the barn, 1 act of oral sex inside the barn, 1 act of anal sex at the house. The difference between the rape and the sexual battery is that in this particular instance, the state's got to show that he was a parent or step-parent. And you're going to hear about his relationship with Brianna. And finally, knowingly cause serious physical harm to another. A person acts knowingly, regardless of his purpose, when the person is aware that the person's conduct will probably cause a certain result or will probably be of a certain nature. Ladies and gentlemen, you're going to hear of brutal sexual attacks that took place on this young boy that left an imprint in his mind that he had to keep quiet. What you're going to hear and what you're going to see is that even as hard as he did, he tried to keep this a secret. There were little aspects, little changes that he couldn't keep quiet, that people noticed, that people saw, and ultimately people became involved. PTSD, or serious physical harm, requires that the state show a mental illness or condition of such gravity as would normally require hospitalization or prolonged psychiatric treatment. You're going to hear from Ryan's therapist, John Rothlow, who he met in 2015. What you're also going to hear is that Ryan has seen John over 60 times to address the ongoing and difficult mental anguish that this boy has gone through. And what's so interesting that you're going to hear in this case, ladies and gentlemen, is way back in 2008, the dates when these acts occurred, and in fact, when counts 1, 2, 3, and 4 started, part of this secret did get revealed. You're going to hear that on or about May 29, 2008, Joni Hughes, who you're going to hear up here, a cousin of Ryan, looked in a toilet. At this point in time, Ryan's a 7-year-old boy. She's going to tell you that she looked in that toilet, and it was full of blood. She was so concerned about her young cousin's bloody toilet and toilet paper that she couldn't handle it. She calls her aunt, Angie Day. And at that point in time, you're going to hear that Adams County Children Protective Services and Bruce England at least initially get involved to conduct some form of an investigation. What you're also going to hear from that, ladies and gentlemen, is that as part of that investigation, Bruce England sat down in Ryan's home. He had, and you're going to hear this testimony, Ryan, the defendant, and Ryan's mother And in front of those individuals, you're going to hear Bruce England ask if Ryan was abused or sexually touched with the person who abused him sitting in the same room. You're also going to hear from Ryan that he was not only threatened, but that his family was threatened, that he was threatened that if he left or if he told anyone about what had happened, he was going to be taken to the children's home right here in town and left. And that happened repeatedly. You're going to hear from Ryan and Brianna, Ryan's mother, about an effort to isolate by keeping Ryan from friends, by keeping Brianna from friends, by keeping Ryan from family, by keeping Brianna from family, by threatening and bullying. You're going to hear lots of words like queer that are repeated over and over from that man directed at Ryan. I want you to keep that in mind as you think about this case. The repetitive use and humiliation of calling this young boy queer, and why one would do that. And I submit to you that the evidence is going to show clearly this was an effort to groom Ryan. This secret that Ryan kept for years ultimately comes to fruition in 2015. After a closed investigation of 2008, where they couldn't find any substantial evidence, although there was blood in the toilet, but Ryan unable to speak at that time with his accuser in the same room. And by 2015, you're going to hear that the defendant's no longer in the house, that he and his former wife are now divorced, and the divorce has been finalized. So without that individual put any more pressure on Ryan, he's at school one day. And you're going to hear testimony from Becky Armstrong, who's known Ryan since he was born, observed Ryan for the several years prior to this, and she's going to tell you that she noticed changes in Ryan, that he became more withdrawn, more angry, more troubled. And in February of 2015, this secret comes out. And it comes out, and what you'll hear is Ryan at school crying, sobbing, having a difficult time controlling his own emotions because he's had too much. Becky Armstrong's going to tell you that she intervened because she was in fact frightened for his own personal safety, as he's going to tell you he wanted to kill himself. Becky will then tell you that she takes Ryan down to Leah Wilkins, the school counselor, and this time, Ryan has the courage, and maybe it's age, and maybe it's he couldn't handle it anymore, but this time he had the courage to talk. This time, the secret becomes disclosed. You'll also hear from a variety of individuals who were involved in an investigation. Bruce England, obviously you heard about CPS's involvement. Investigator Kenny Dick, an investigator with the Adams County Prosecutor's Office, and Special Agent Shane Hanshaw with BCI. Now, they are going to talk to you about their attempt to collect evidence, both physical evidence, to verify, to corroborate Ryan's story. They'll tell you about the efforts that they did to engage in that. You're also going to hear and see Ryan do what's called a forensic interview at Cincinnati Children's Hospital, where he sits down with the social worker and begrudgingly and reluctantly talks about being raped by his former stepfather. You'll get to see both his testimony on that stand in the interview and judge for yourself his own credibility. You'll also hear that about a week after that interview at Children's Hospital, he returns. You'll hear that because of the type of disclosure that Ryan gave, that they decided to do a medical examination, a sexual assault examination, where they used items such as a colposcope to look in the rectum of this child. They completed a blood panel and took blood to test for sexually transmitted diseases, and also did an overall physical evaluation. You're going to hear from Dr. Edward Connor, psychologist in Erlanger, Kentucky. And his expertise is dealing with not only sexual assault victims, but sex offenders. And he's going to discuss with you reasons, many of which are common sense. He's going to discuss with you the reasons why this boy had to be quiet, why he kept it internalized, why he was afraid to tell. He's going to tell you that the things that Ryan experienced are consistent with what victims of sexual abuse engage in. You're also going to hear from John Rothflow, as I referred to him before, Ryan's counselor. When you hear and listen to some of the other family members, including Wayne, Ryan's grandfather, Ryan's mother, school personnel, talk about the changes in Ryan, the anger, the sleep disturbances where he wouldn't sleep at night, the suicidal ideations. You're also going to hear that one of the most difficult times for Ryan was when he was woken up in the morning. If he had to be roused out of sleep, he would wake up startled and frightened and panicked, something that was noted prior to his disclosures by his family members. They couldn't put the pieces together because at that point he was silent. But with John's help, putting the pieces together, you're going to hear that these symptoms, including many others, were symptomatic of somebody who's gone through post-traumatic stress disorder. And what I'll ask you to be aware of as well when John and Ryan testify is what's extraordinarily interesting is he starts exhibiting these symptoms. He's going to, along with the other family members, he's going to tell you that these symptoms arose when that man left the house. What you'll hear from Mr. Rothflow as well as Dr. Connor, once you take the stressor, like a war, out of the environment, that's when the post-trauma occurs. And that's all relevant, ladies and gentlemen, because what I'm going to ask you, and when you look at this case, it's not just Ryan's word. It's corroborated time and time again. You have physical evidence right after the time that this happened, when Ryan is 7 years old, where he's bleeding in the toilet. And you'll hear Dr. Duma discuss how that's consistent or could be consistent with somebody who's been raped anally. But you're also going to see all these psychological symptoms, the subtle things that were changing in Ryan's life, the anger, the sleeplessness, and the suicide. So I want you to look and listen to all of the evidence and the testimony in this case. Because what you'll hear is that victims of sexual abuse and child sexual abuse suffer in secret, suffer in silence, and are put up by people who threaten them, harm to them, harm to their family, isolation, humiliation. And this suffering and this secret cannot get exposed until that individual feels comfortable with doing so. I also want you to focus on the courage that this young man, and I submit to you, will display in this case. To walk into a room with 15 strangers as well as 10 to 20 other people in here and discuss things that he would never want anyone to know. And you're going to hear him talk about how he didn't want to tell his mother, and still has not told her the details, because he wants to protect her. As I said in the beginning of this, ladies and gentlemen, you're going to have the most important role in this trial. You are going to get to listen to all of the witnesses. You're going to get to look at all the exhibits. And you yourselves are going to get to judge the credibility in this case. You can ask yourselves why a young boy who seemingly unsuspectingly put blood in a toilet when he's 7, keep a secret for years, and then ultimately in 2015, after claiming he wanted to commit suicide, come forward with that secret for no motive, no reason. And the reward he will get, and you will see, ladies and gentlemen, is to come in here in a room full of strangers and talk about being raped by his stepfather. And I'm confident that when you listen to the witnesses, you've seen the exhibits, and you've tested the cooperation for yourself, that without all shadow of a doubt, ladies and gentlemen, the evidence is going to show that that man raped Ryan Appleton. Thank you.
All right, thank you, Mr. O'Reilly. I'll say this, as I will when the defense gives their opening statement, that the opening statements of counsel are not evidence. All right, the defense then has reserved the opening statement until after the state's case, so as the state prepared to call its first witness.
Yes, Your Honor. State would call Joni Hughes, please. Your Honor, I'd like to move the podium back to the
That'll
side.
be fine.
Thank you.
Come right around here and then stand before you get into the witness stand and be sworn in, please. Raise your-
Dash your raise your right hand. You solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Thank you. Have a seat, please.
Write your name, Inquire.
Good afternoon, Joni. Is it okay if I call you Joni?
Yes.
All right. Can you state your name, spell the last name for the record?
Joni Hughes, Hughes.
And Joni, how old are you?
24,
And Joni, where do you currently live?
Florida.
What do you do down there?
I work with my aunt. She owns her own business,
Okay, what type of business is that?
a cleaning business.
Okay, and who's your aunt?
Donna Case,
Okay. Who do you live in Florida with?
my mother.
What's your mother's name?
Angela Day.
Where did you live back in May, December of 2008?
Yates Road.
I'm sorry?
Yates Road.
Yates Road? And who'd you live there with?
My mother.
And that's Angela Day?
Yes.
And when did you move into the Yates Road address?
In like 2006.
So in 2008, how old would you have been? So what's that?
16.
About 16? Okay. Anyone else live there with you other than your mother, Angela?
My brother,
What's your brother's name?
Brandon Hughes.
Okay. Were you in school at that time, Joni?
Yes.
Where'd you go to school?
Manchester High School.
You know what grade you were in back in May of 2008?
I would say 9th grade, 10th grade.
Now, how do you know Ryan Applegate?
He's my cousin.
And where did Ryan live back in May of 2008?
Right beside us on Yates Road.
And that's in Adams County,
Yes.
Ohio?
Yes.
And back in 2008, do you know who Ryan lived with?
His mother and Kevin.
So the defendant, Kevin Gaffin, was living there in 2008?
Yes.
So you know who Kevin Gaffin is?
Yes.
Can you point him out and identify what he's wearing for the jury?
A suit, gray.
You know, State asks a record reflectification of the defendant by this witness.
And that's so ordered.
So Ryan's your cousin.
Yes.
You knew how old Ryan was back in 2008?
6.
Do you know his date of birth?
I don't.
Okay. What was your relationship with Ryan back in 2008?
We were really close.
Was there ever a time that you lived next to Ryan with your mother that the defendant wasn't living with? Brianna and Ryan, do you know?
I'm not sure.
Okay. But your recollection is when you lived on that Yates Road address that the defendant lived there with Brianna and
Yes.
Ryan? Okay. So you were very close with Ryan.
Yes.
How often did you see him?
Well, he would come down a lot before Kevin started living with them.
I didn't understand that last part, I'm sorry.
He was there a lot before Kevin started living there.
Okay, so if he was there a lot before Kevin started living there, then you would have lived there with your mother next to Ryan and Brianna before Kevin lived there? The defendant lived with them?
Yes.
Okay.
I think so.
All right. So you used to come down a lot?
Yeah.
All right. What kind of things did you guys do together?
Ride the four-wheeler. That's about all we did.
When you say come down a lot, what do you mean?
Like every other day he would come down.
Okay. Did you ever go down to his house?
Yes.
Were you welcome down at his house?
Yes.
Okay. Was he welcome at your house?
Yes.
Okay. What was your relationship like with Brianna, Ryan's mother, Brianna Weisskopf?
We were close.
Okay. Describe Ryan as a 6-year-old boy. What was he like?
Like any other 6-year-old boy, he liked to play,
Okay.
come to the house.
Seem happy?
Sometimes.
Now, at some point you said, and then when Kevin moved in there, speaking of the defendant, did something change when?
Yes, he wasn't allowed to come back down there anymore.
Okay. And do you know about what time period that was?
I'm not sure.
Okay. And how do you know he wasn't allowed to come down?
He just stopped coming,
Stop coming. Okay.
and he would tell me.
Okay. So when you lived back there in 2008, how long did you live? When did you move to Florida?
6 years ago, 5 years ago,
So 2011,
we moved there in 2010.
2010. When you moved from that location, was the defendant still living with Brianna and Ryan, if you know?
I don't remember.
Okay. So you've been gone down in Florida for about 6 years?
Yeah.
Okay. Now, at the time that, so you moved in, you indicated and lived next to the defendant for a period of time. Were you ever around the defendant?
Yes.
Okay. How often?
Not very often.
Why not?
I just stopped going down there
Why'd you stop?
because of what happened.
Did you ever see the defendant interact with Ryan?
No.
So let's take you to May of 2008. You indicated you were in the 9th or 10th grade. At that time, was Ryan still coming down to see you?
No.
Okay. Did something happen to give you some concern in 2008?
Yes.
Can you explain, ladies and gentlemen of the jury, what that was?
He came down to my house, and I was getting ready. He came to get me to ride the four-wheeler, and he was using the restroom, and I was kind of worried because he was taking a minute, and I look back, and as he's wiping, he had blood on his toilet paper.
Were you in the bathroom with him, Jim?
Yes.
Okay,
Well, I was getting ready. He was behind me.
I understand. But in the same bathroom?
Yeah.
You could clearly see into the
Yeah.
bathroom? As a result of seeing that, what, if anything, did you do?
I asked him why there was blood on his toilet paper, like what happened, and he wouldn't tell me at first.
Okay.
He
At
was-
first, so what happened after that?
We go to get on the four-wheeler, and he has to get behind me because I drove back, and he told me that his private
Objection.
part.
No, it's not offered for, yeah, can we approach?
Yes. What's the expected response?
Well, she's going to say what he said, but it's not offered for the, it's for a non-hearsay purpose based on, explains her conduct, what she did next as a result of that information.
What's it going to be? That he's complained of something?
Yes, that the defendant touched him, is what she'll likely say.
All right, well, I'll explain to the jury they cannot consider this statement for the truth of the matter asserted and overrule the objection. Thanks. All right, that objection is going to be overruled. The response, expected response is to be considered solely to explain why this witness did what she did, not for the truth of the matter that was, the statement that was made to her. You may continue.
Thank you. And
You
what
may answer
right?
the question.
You can answer the question.
And he was pulling at his pants and asking why I was pulling at his pants, and he told me that his private part hurts. So I asked him why his private part was hurting, because it's not supposed to hurt, and he said he's not allowed to tell me, and I kept trying to get him to tell me, and he still wouldn't tell me, and he finally said that Kevin hurt him.
Armed with that information, what did you do?
I immediately got off the four-wheeler and went and called my mom,
And your mom's name again?
Angela Day.
Now, Joni, after you called, what happened? What involvement did you have with Ryan after that?
I never ever seen him, ever.
Did you ever see the defendant after that?
Not really,
Did you ever see Brianna after that?
no.
Is there a reason?
I'm not sure, I don't know.
Okay, that's fair enough. Were you ever interviewed by anyone about what Ryan told you?
No,
So if Bruce England, who's going to testify, indicates he had a face-to-face interview with you, you don't recall that?
no.
Okay. Thank you, Your Honor.
Ross?
Just one more. Good afternoon, Ms. Hughes. My name's Aaron Haslam. Obviously, I represent Kevin Gaffin. So I was having difficulty hearing you, so I may be repetitive with some questions. Forgive me for that. Where do you currently live?
Venice, Florida.
I'm sorry?
Venice, Florida.
Venice, Florida. How long have you lived there?
6 years, 5 or 6 years.
And you live there with your mother?
Yes,
Anyone else live with you?
my brother and his wife,
And how old is your brother?
25,
And how old's his wife?
25.
Are you currently working?
Yes.
Where do you work?
For CNC cleaning,
And how long have you worked there?
3 years.
And so, it's correct you graduated from Manchester High School in 2010?
Yes.
Did you have a graduation party?
No,
You did not?
no.
You don't recall having a graduation party where Kevin Gaffin cooked for you and the other attendees?
Like, I thought you meant like a graduation party. Yes, a get-together, yes.
And that would have been after 2008?
No. Yes, yes.
So, just so I understand, in 2010, you had a get-together where Kevin Gaffin
cooked for
I
you
don't
and other
remember if
attendees?
he cooked there or not. I don't remember.
But he was present?
I'm not sure. I don't remember.
So you don't remember, you don't recall, you...
Yes, we had a graduation party, but no, I do not remember if Kevin was there or not.
Excuse me, young lady in the back row there, you need, if you're going to observe, you need to stop with any gestures or reactions. Just listen. All right, continue.
So you don't recall this cookout?
Yes, we had a cookout, but I do not remember Kevin being there, no.
So you don't remember him cooking for you?
I don't remember him being there at all, no.
So if I understand correctly, as of 2008, after this alleged incident that you previously testified about, you did not see Brianna, Kevin, Ryan, anyone?
No, hardly ever at all. Maybe driving down the road, that'd be it.
But you didn't see them in any kind of family gatherings,
No.
cookouts, get-togethers? So your last contact with them was 2008?
Yes.
So what month did this incident occur?
May? I believe May?
May 2008?
Yes.
And that was at 277 Yates Road?
I don't think it was 277. I'm not sure what the number was. I don't remember.
Have you been in any trouble in Florida?
Objection.
I'll sustain that. The form of question is not proper.
Were you recently arrested in Florida?
Objection.
Sustained.
Have you talked with anyone about this case?
No,
You haven't talked to your mother about this case?
no.
You're living with her?
Other than when I told her.
I mean, since 2008.
No.
You currently live with your mother?
Yes.
Did you travel up here with your mother?
Yes.
You didn't have a conversation with
We
your mother?
don't talk about it.
Are you and your mother close?
Somewhat, yes.
So it's my understanding that you traveled from Venice, Florida. Did you drive, fly?
Fly.
2-hour flight?
Yep. And I slept the whole way.
And then did you fly into Cincinnati?
Yes.
So an hour drive
Mhm.
to here?
Yes.
And you didn't have a single conversation with your mother?
About this case, no.
No additional questions?
Redirect.
Is this something you enjoy talking about, Joni?
No.
Your testimony is you don't recall speaking to the defendant at a graduation party,
No.
but you've seen the defendant and Brianna and Ryan periodically since 2008,
Yes.
just not that often.
Right.
Nothing else, Your Honor.
All right, let me step down. Next witness.
Yes, Your Honor. State would call Angie Day.
Next, you please raise your right hand. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. Thank you. Have a seat, please.
Right to me, Inquirer.
Thank you. Ma'am, can you state your name, spell your last name for the record?
Angela Day, D-A-Y.
And Ms. Day, how are you, ma'am?
I'm good.
I said,
Oh.
how old are
How
you?
old am I?
Yeah,
I'm 45.
45, all right. Who's your daughter?
Joni Hughes.
Do you have any other daughters?
No.
Okay. Where do you currently live?
Venice, Florida.
And how long have you lived there?
6 years.
Moved there in 2010?
Yes.
What do you do down in Venice, Florida?
I clean for a living and I bartend.
Where were you living back in 2008?
In Manchester, Ohio, on Yates Road.
And when did you first move on Yates Road?
Around 2004, 2005.
And who did you live there with?
My daughter and my son,
What's your son's name?
Brandon Hughes.
Who was your neighbor?
Brianna Weiscott.
And when you first moved in 2004, 2005, who lived there with her?
Kevin Gaffin and Ryan Applegate.
So, and you know who Kevin Gaffin is?
Yes,
You
sir.
see him in the courtroom today?
Yes, sir.
Could you point out and describe what he's wearing, please?
He's wearing a gray suit with a pinkish looking tie.
The state would ask record reflect the indication of the defendant by this witness.
Sort of.
Thank you. So when you first moved into the location on Yates Road, the defendant was already living with Brianna?
Yes.
Okay. And were they your next door neighbors?
Yes.
What was your relationship with Ryan back in 2004, 2005?
He's my nephew.
Did you see him a lot, or?
Not quite often, no.
Okay. Did you work a lot when you lived at the Manchester address?
Yes.
How many jobs did you have?
I had 2.
Okay. So you wouldn't know necessarily when Ryan was coming or going from your home?
No, sir.
Was he welcome there?
Absolutely.
Okay. What type of relationship did you have with Brianna?
Good.
Okay.
Good relationship.
Did you see her often?
No, not a whole lot.
Did you guys work together for a period of time?
We did.
Okay. Where did you work?
At Bottoms Up.
Okay. How well do you know the defendant, Kevin Gaffin?
I know Kevin Gaffin pretty well.
Okay. Did you ever see him interact with Ryan?
Interact is,
See him do anything together?
yes.
Okay. How often would you see Kevin and Ryan together?
Like I said, not a whole lot. They pass by house quite often.
Okay. Anything that you saw ever give you pause that you saw between the defendant and Ryan?
No.
Okay. Did you receive a phone call back in 2008 that gave you some concern?
Yes, sir.
Who called you?
My daughter, Joni Hughes.
And do you know where you were when you received that call?
I was working at Cantrell's
What's Cantrell's?
in Manchester.
What type of business is it?
It's a gas station.
Okay. And how do you recall that specifically that you were there?
I was just there working. I was a cashier, and she gives me a phone call, letting me know that she had something that she needed to tell me, that she was concerned.
Okay. And did she tell you?
Yes, sir.
And what did she tell you?
She had told me that Ryan had come over to the house.
Well, I'm going to overrule the objection, and again, the testimony of the witness is not to be, as to the hearsay that she was told is not offered for the truth of the matter, asserted to explain her actions. I assume that's what you're going to do.
That's correct, Your Honor.
So the court will overrule the objection and admit it for that purpose. But you could go ahead and answer.
You can answer the question.
Go ahead and answer.
She'd give me a phone call and told me that Ryan was over and that she was in the bathroom fixing her hair and that he had used the restroom, and she glanced over at him through the mirror, and when he had wiped his butt, he looked at his toilet paper, and the toilet paper had blood on it. She had asked him why his butt was bleeding, and he just said it does that sometimes.
And based on that information, what, if anything, did you do?
When she gave me the phone call, I had called my sister.
And your sister is whom?
Donna Case in Florida.
Okay. And how's she relating to Brianna or Ryan?
It's their aunt.
Okay. All right, go ahead.
And I told her what my daughter had told me and asked what I should do.
What did you do? Not what she told you, but what did you do?
I called Children's Services after I got off the phone call with her.
And who did you speak to?
Bruce.
Bruce England?
Bruce England.
Did Bruce England ever do an interview with you that you recall?
No.
After that disclosure to you by your daughter, Joni, did you ever confront the defendant about it?
No.
You say you've known him a long time, right?
Right,
Grew up in Manchester.
right.
Is there a reason that you didn't?
Just being neighbors, I just thought Children's Services would handle it in the way they should have handled it.
Okay. Did you ever talk to Brianna, Ryan's mother, about this?
No, I did not.
Was there a reason you didn't?
Same thing, just thought, Children's Services would handle it. We was a neighbor and kind of scared of what would happen if someone knew I was the one that called.
Well, why were you scared?
Kevin's been known to have a temper, and I lived there by myself with my children.
You indicated, how far was your home from Ryan's home?
Maybe an acre in between.
Any other neighbors around on that side of the street?
No,
Did you ever hear or see the defendant call Ryan any names?
no,
You ever saw him discipline Ryan?
no.
Did Ryan ever act differently when you were around Ryan and the defendant entered the room?
Yeah, he learned to mind a little bit better and stuff when Kevin was around.
Now, after that phone call that you made to first to Brianna and Children's Protective Services, did your contact change between Brianna?
No,
So it stayed the same?
yes,
Change with Ryan?
no,
Stayed the same?
yes.
I think your testimony was you've never talked to the defendant about this, have you?
No,
You've never talked to Brianna about it, have you?
no,
You ever talked to Ryan about it?
no.
It's not something you like to talk about, is it, this day?
No.
Are you done?
Yes, Your Honor, I'm sorry.
Cross?
Good afternoon, Mr. Hay.
Good afternoon.
So did I understand correctly, you moved in next to Brianna in 2004, 2005?
Yes.
And Kevin Gaffin was living there at the time?
I'm pretty sure Kevin was living there at the time. I don't think they were married, but he was living there.
Do you recall, and you're related to Brianna, correct?
Yes,
Do you recall Brianna being married to Roger Applegate Jr.?
yes.
Are you aware that they were divorced in 2007?
I'm not for sure when they got divorced, actually.
Did you ever live next to Brianna while she was still married to Roger Applegate?
Objection, Judge.
I'll overrule.
I'm maybe for a little while, maybe.
And the first time you lived next to her was in 2004?
2004, 2005, not really for sure the exact date.
But it's during that time frame.
Yes.
Have you and Kevin Gaffin, well, first off, have you had conversations on Facebook through Instant Messenger?
Yes.
And when did those stop?
When he texts me and he
Have
texts.
you had any recent discussions?
No.
Have you had discussions since 2008 on
Yes.
Instant Messenger?
Yes.
And would it be safe to say that your opinion of Brianna and her mothering habits are not good?
Objection.
Sustain.
Have you had an opportunity to observe Ms. Weiskup over the years? Brianna,
Yes.
being her neighbor, being her relative?
Yes.
And you said you worked together at Bottoms Up?
Yes.
When did you work at Bottoms Up with Brianna?
2006, 2007, 2006, I think is what it was.
You ever observed Brianna drinking?
Objection.
Sustain.
Did you talk with your daughter about this case on the way up here?
No.
Not even as to why you were coming to court today?
Well, yeah. Yes, I can say we probably did.
Did you discuss the facts of this case at all?
No.
When did you fly in?
Sunday.
So you've been here since Sunday.
Yes.
2-hour flight from Florida to here.
Yes.
Hour drive from Cincinnati Airport
Yes.
to this area. Where are you staying?
At Brianna's.
Is your daughter staying with you there as well?
No.
If you know, do you know where she's staying?
Yes.
Where?
She's staying at her grandmother's, Candy Hughes.
Did you and Brianna discuss this case at all?
No.
You've been there since Sunday and the topic did not come up at all?
Not the case. No. Not.
So the incident that you described involving Ryan, that allegedly occurred at your house?
Yes.
And at that time, did you keep toilet paper in the house, I assume?
Yes.
How about alternative forms such as baby wipes or moist wipes?
No.
You didn't keep those in the house?
No, I don't have children, babies.
So you have a son, is that correct?
Yes.
How old's your son?
As of today, he's 25.
And your daughter Journey's 24? Is
Yes.
that correct? Do you recall a graduation gathering that you had for your daughter Journey in 2010 when she graduated from high school?
Yes.
Do you recall, was Kevin Gaffin present at that?
Yes.
Did he cook that day?
Yes. Well, I'm not sure if he cooked, but yeah, he was there.
And obviously your daughter was present.
Yes.
Was Brianna present?
Yes.
Ryan present?
Yes.
Brenda Weiscup present?
Yes.
Wayne Weiscup?
No.
No. Do you recall, did you interact with Kevin that day?
Yes.
Did your daughter interact with Kevin that day?
Absolutely.
Did Brianna interact with you and others?
Yes.
Did Ryan interact with you and others?
Yes.
No additional questions?
Redirect.
Thank you, Your Honor. Ms. Day, do you have many family gatherings that you each would address?
No.
Matter of fact, is that one of the few gatherings you ever had involving the extended family?
Yes.
Did you ever see family over at Brianna and the defendant's house when Ryan was living there?
Family as in
Did
his...
you ever see many people with family friends?
Well, yes.
It was unusual for family to visit Brianna and Ryan while the defendant was living there?
No.
It wasn't. Did you ever visit?
Yes.
How often?
Not very often.
Okay. Was there a reason for that?
No, no reason. Just worked a lot.
You know if Ryan ever had many friends over at his house?
Not that I recall.
How many people were at this graduation party we've heard so much about in 2010?
Oh, maybe 15 at the most.
Number of people there?
Yeah.
Thank you. Nothing further now.
All right, thank you. You may step down. I think we'll take a break now. It's been about an hour and 10 or 12 minutes, so we'll break for 10 minutes, and we'll be back in 10 minutes, and we'll try to get restarted then in about 15 minutes. And again, during the recess, remember the instructions of the court. that you're not to discuss the matter with anyone or permit to be discussed in your presence. You're not to talk with any of the persons involved or spectators or anyone else about the case. You're permitted to be discussed with you. And you may make phone calls, let people know about where you're at. Make sure you turn your cell phones off and come back in. Don't use them to communicate with anyone about the case or attempt to learn any information about it. So I have, it's just before 3, so we'll be back about a couple minutes before 3:15. I'd like to get started back at 3:15. Report to the jury room when you return. Thank you. Be seated, please. All right, your next witness.
In our stable, I have called Kenneth Dick.
Solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth. So help you God.
I did.
You may inquire.
Thank you. Sir, can you state your name and spell your last name for the record?
My name is Kenneth Dick, D-I-C-K.
And how are you employed, sir?
I'm currently employed as the investigator for the prosecutor's office here in Adams County
How long have you been employed in that capacity?
for approximately 18 years.
What did you do before that, sir?
I was a special deputy with the Adams County Sheriff's Office, but prior to that I was working construction.
Okay. And you say you're an investigator for the Adams County Prosecutor's Office. What's that mean? What are your job duties?
I assist local law enforcement in the filing of criminal complaints, conduct independent investigations, interview victims, witnesses, suspects, and assist the prosecutor during court procedures.
Are there certain cases in Adams County that you exclusively have responsibility to investigate?
Yes, sir.
What type of cases are those?
Cases of sexual assault.
And why is that, Mr. Dick?
Prior to me, Detective Heikemper was the detective who handled these cases. He was with the Sheriff's Office. They also, around 2008, he started to handle burglary cases, and it was getting too much to handle all the cases. So it was decided and asked if I would assist in that, and then I took over the cases.
Do local law enforcement or the Sheriff's Department also investigate sexual abuse cases?
They start the initial investigation if they are contacted, but then it is turned over to myself.
And that's a decision that's been made by whom?
By the local law enforcement chiefs, the sheriff, and the prosecutor.
Okay. Do you have any special training in investigation?
I have a bachelor's degree in criminal justice from the Ohio University. I am a special deputy, like I say, with the Sheriff's Office that has Ohio Peace Officer training certified, seminars, training, and a lot of on-the-job training.
So you're a certified peace officer as well?
Yes, sir.
When did you receive that certification?
In 1996.
Is it current today?
Yes, sir.
Have you any specialized training in investigating sexual assaults or sexual abuse cases?
I've been to a couple training seminars as well as training with other officers.
You receiving special certification in that area?
No, sir.
Okay. Now, did you have the occasion, Mr. Dick, to be involved in an investigation involving the defendant Kevin Gaffin?
Yes, sir.
And you see Kevin Gaffin in the courtroom today?
I do.
Can you point out and identify what he's wearing, please?
Mr. Gaffin is the gentleman sitting to the right of Counselor Aaron Haslam. He's wearing a suit with a pink tie.
In our state, ask the record reflects identification of the defendant by this witness.
So ordered.
Can you explain the circumstances surrounding your involvement in that case, Mr. Dick, in this investigation?
I received a referral from the Adams County Children's Services.
And who sent you that referral?
I was contacted by Al Lewis.
And is that how, well, just walk through how you get involved typically in a sexual abuse case, first of all.
It depends a lot on how it's reported. If it's reported to a law enforcement agency, then they would contact me. If it's reported to Children's Services, then they would start their own investigation, and then I would receive a referral from the Adams County Children's Services.
So in this case, you received a referral from the Adams County Children's Services?
Yes, sir, that's correct.
And what's the next step that you take when you receive the referral? And what was this referral specifically, if you recall?
This referral stated that there was an allegation of sexual abuse pertaining to a Ryan Applegate by Kevin Gaffin.
And armed with that information, what's your next step?
The next step is Children's Services had the victim interviewed at Mayerson, and then after I received the interview report, then I would start my investigation.
So you didn't interview Ryan Applegate, is that true?
That's correct, yes.
Is there a reason that you don't interview
The reason is because when they're interviewed at Mayerson, the interview is both video and audio recorded. That way, the victim's not having to tell their story 2 or 3 times to 2 or 3 different individuals. With one interview, I'm able to review the video and audio to get more information regarding the incident.
Is that normal procedure? Is that what you do in a typical
Yes,
sexual
sir.
abuse case? Is that what you did in this case?
Yes, sir, it is.
Okay. Now, after you reviewed the Mayerson interview with Ryan, what, if anything, did you do next?
I went to the scene of Ryan's residence, which is located at 277 Yates Road, and photographed the area where Ryan indicated the sexual assaults occurred.
And that's Yates Road, that's in Adams County, Ohio, is that correct?
Yes, sir, that's correct.
Now, Mr. Dick, I want to show you some photographs of them marked, I would like to start with State's Exhibit B. Can I, 2B, I'm sorry. Can I approach?
Yes. Do you have a list of exhibits, by the way?
I do, Your Honor.
Yes, sir. Thank you. Is it ready, Rick? Okay. The machine's ready.
All right, thank you. Mr. O'Reilly, if there's no objection by Mr. Haslam, will assist with the exhibits and just put them on as I go.
Just for the record, Mr. Haslam's just reviewing the photograph.
It's a little blurry, Mr. O'Reilly. That's perfect. And before we talk about State's Exhibit 2B, did you go to that home on Yates Road with anyone?
No, I was by myself.
You were by yourself?
Yes, sir.
And I'm going to show what's been marked for purpose of identification only at this point. State's Exhibit B. Can you tell, ladies and gentlemen of the jury, what that is?
Wait a minute. You have your exhibits as numbers. Is it 2B?
2B, I'm sorry.
All right.
2B.
This is the residence located at 277 Yates Road in Manchester.
And is that where Ryan Applegate lived with his mother, Brianna,
Yes, sir.
and the defendant, Kevin Gaffin?
Yes, sir.
And when did you go take this photograph?
On April the 1st of 2015.
Next, I'd like to show you what's been marked as State's Exhibit 2C. Do you recognize that photograph?
Yes, sir.
And what is it?
This is also a photograph of the residence located at 277 Yates Road in Manchester, Ohio.
And these photographs all taken on April 1st, 2015?
Yes, sir.
And you took those photographs?
Yes, sir, I did.
I'd like to show you what's been marked as State's Exhibit 2D, please. And for purpose identification, you explain what we're seeing in that photograph.
This is another photograph of the residence located at 277 Yates Road in Manchester.
2E, please. What are we looking at here?
This is a photograph of a barn that is also located on the property,
What-
277 Yates Road.
What's significant, if anything, about that barn?
This is one of the areas where Mr. Ryan indicated that one of the sexual assaults occurred.
That's why you took a photograph of that barn?
Yes, sir, that's correct.
I'm going to show what's been marked as State's Exhibit 2F, please. we looking at there, Mr. Doug?
This is the inside of the barn that was exhibited on the last photograph.
Just took that picture for the same purpose?
Yes, sir.
All right. Show what's been marked States Exhibit 2G. What are we looking at here?
This is a photograph of the inside of the residence located at 277 Yates Road in Manchester.
Is that the front door of the residence, to your knowledge?
That is the door that faces, does not face Yates Road.
Okay. So it'd be the
It
back.
would be what would be considered the back door, yes.
I'm sure it's been marked States Exhibit 2H. What are we looking at here?
This is the living room area of the residence that I photographed at 277 Yates Road, Manchester.
And why did you take that photograph?
This is the area where Mr. Ryan Applegate indicated that one of the alleged sexual assaults occurred.
Show what's been marked States Exhibit 2I. What are we looking at there?
This is a close-up of the area where Mr. Ryan Applegate indicated the alleged sexual assault happened.
And specifically, where did he indicate?
In the front of the couch.
Anything significant about the coffee table?
No.
2J. Tell ladies and gentlemen of the jury what this is.
Just another view of the area that Ryan Applegate indicated that the alleged sexual assault occurred.
And 2K, please. And what are we looking at here?
This is a photograph of the garage
On the property?
at the property at 277 Yates Road.
Thank you. Now, all those pictures fairly accurately portray the home, the barn, and the garage as they appeared at least back in April of 2015.
Yes.
What other steps, if any, did you take to collect additional evidence, or did you take any steps to collect evidence at the scene?
On May the 11th of 2015, myself and a special agent with the Ohio Attorney General's Office, BCI, who does crime scene, went back to the residence to see if there's any evidence that we could collect.
And who was that special agent?
Special Agent Shane Hanshaw.
And why did you contact him?
He does the crime scene for our area.
For Adams County?
Yes, sir.
Okay. And that was when? I'm sorry?
On May the 11th of 2015.
And after you contacted him, what happened next?
Then we just continued with the investigation, tried to collect as much evidence, and then prepared the case for trial.
What steps did you take to collect evidence with Mr. Hanshaw? Did you go back out?
I went with him, yes, sir. He did the search. I was just there to assist. He photographed the area. He also searched the living room area where the alleged sexual assault had occurred.
Okay. And was he given consent to search?
Yes.
Okay. And you know, and I know and we'll hear from him later, but you know what test he conducted to try to, what he was looking for?
I know he was looking for bodily fluids in front of the couch where the sexual assault had occurred.
And how many sexual assaults would you say you investigated over the years?
Probably dozens.
Dozens?
No exact number.
Now, if there's a period of time between the alleged assault and the disclosure, can you expect to find physical evidence?
It's drastically reduced the possibility of finding physical evidence the longer the time span between the occurrence of the crime and the disclosure, yes.
Does it matter, like carpets, for example, being cleaned, that type of thing?
Oh, sure.
How about if exposed to the elements?
Yes.
But still, you called BCI to see if any evidence could be collected, is that true?
That's correct.
Do you know if there was any, say, DNA? I know obviously there had been DNA, but was there any sperm found at the scene?
We did not find any, no, sir.
But efforts were made?
Yes, sir.
All right. Now, Mr. Dick, anyone else involved in this investigation other than you and Mr. Hanshaw?
In regards to?
Well, making a determination whether or not to present charges or not.
I gather the evidence, I get the case file together, and then I present it to the prosecutor.
Who did you interview in making that determination?
I did not interview. The only one I talked with briefly was family members. Brianna, when I was there at the scene, But to sit down and take a recorded statement, I did not.
Okay. And they didn't give written statements either, did they?
No, sir.
Okay. And you didn't prepare really any narratives for this case either,
Correct.
is that correct?
Yes.
Is there a reason?
The case file, when you present like a report or a case file, when law enforcement does that, they do it to summarize everything they've done to when they present it to the prosecutor's office. The prosecutor has an idea of what they've done. Since I work with the prosecutor's office, I'm there during the determination. I just have all the items there with me to present.
When did your investigation conclude, Mr. Dick?
I would believe that the case concluded when presented to the grand jury.
So at some point, you made a determination based on your investigation that this is the type of case that needed to be presented to the grand jury?
Yes, sir.
And that's in fact what happened?
Yes, sir.
1 second, please, Your Honor. Mr. Dick, is it true that even though after the grand jury you've continued to reach out to speak to other potential witnesses in this case?
Oh, yes, sir. Correct. Yeah.
Thank you.
Cross.
Good afternoon, Mr. Dick.
Good afternoon, sir. Good.
Sorry, Investigator Dick. You said you work for the Adams County Prosecutor's Office, and you've been there quite a while, is that correct?
18 years, yes, sir.
18 years. And these particular cases where sexual assault is alleged, those are handled solely by the Adams County Prosecutor's Office?
It depends on conjunction with, if it's reported to the sheriff's office or the police department, then they would do the initial, but then I'm contacted, yes.
Would it be correct that the procedures and policies to be followed have been put in place by the Adams County Prosecutor's Office in these types of cases?
In regards to?
When the referrals come from Children's Services?
Yes.
And does one of those include referring the alleged victims to Cincinnati Children's Hospital, to the Marison Center?
I believe that's a policy, yes.
And that's for a forensic interview?
Not necessarily a forensic interview, no. It's for an interview to determine if what medical steps is needed for them.
So am I correct, you took all the steps necessary, but you didn't find any evidence of sexual assault at 277 Yates Road?
I found no physical evidence, that's correct.
And that was after a thorough review by BCI?
Yes.
I think it's called luminescent. Is that where they put the
chemicals? Correct, yes.
over and they didn't find anything?
No, sir.
Do you have any ideas, the photographs, may I see the exhibits? May I approach the witness, Your Honor?
You may.
So I'm showing you what's been marked for identification purposes, State's Exhibit 2F.
Yes, sir.
That was the condition of the barn in 2015. You have no idea if that's what it looked like in 2008.
Correct.
Correct?
Yes.
So all these photos are 8 years later, or 7 years later?
Were taken on April the 1st of 2015. Yes, sir.
So you said your investigation, well, initially you testified that your investigation ceases once you turn it over to the prosecutor for a grand jury. Is that correct?
That stage in the investigation, yes.
But yet you continue to investigate, collect evidence, do interviews and other things after that.
If we get additional information, then yes, I follow up.
Judge, can we approach?
You may.
At this point in time, it looks like Mr. Haslam wants to introduce the polygraphs. I would object to introducing him through this witness in conjunction with the court's ruling. I don't mind if we have stipulations to both as a...
I assume they'd be joint exhibits.
Yeah,
Joint exhibits 1 and 2 would be the proper way to bring them in by stipulation.
And I would prefer, and I would ask that there be absolutely no testimony with respect to these, given the court's ruling. And I don't think Investigator Dick, obviously he's not the one that conducted the polygraphs to begin with, but I would like to note our objection that he not be able to testify about these at all in any manner. And then if we are going to admit them, I would admit them as joint exhibits, not as defense exhibits.
Correct. They'll be admitted as joint exhibits or court exhibits. If we
or court
prefer.
exhibits, however you
I'll
want
make
to do it.
Actually, maybe that's the better way to do it. We'll make those, have those remarked as court exhibits 1 and 2. They'll be admitted by stipulation. And that means there won't be any testimony about them.
So that's our objection.
Because that was the issue I was concerned about, misleading, and actually it was your suggestion. It was a good one, I thought.
My understanding, I thought, was the court's ruling we're not allowed to get into the actual tests themselves. But Kenny actually observed one of the tests, and my questions are not going to the test itself. It's going to his experience, what happens typically when someone fails a polygraph.
Well, that's not admissible. The only evidence that is admissible on a polygraph is whether at the time the person was, at the date and time, the person was being truthful or deceptive. And that's it, nothing more. And so any evidence beyond that is not admissible. So, I'll sustain the objection, but you'll be able to present those, and at any time, whenever you two sides decide you want to do it, we'll bring it in as a joint exhibit, as a court exhibit. Okay. All right, you may continue.
So if I understand, as you sit here today, you did not collect any physical evidence that indicated a sexual assault occurred at 277 Yates Road?
That's correct.
No additional questions.
Redirect.
Thank you. Mr. Dick, it wasn't for a lack of trying, was it?
No, sir. We exhausted all efforts.
All right. Now, you weren't notified back in 2008 when there was initial disclosure about this potential sexual assault, were you?
No, sir.
If you were notified back in 2008, and during the course of your investigation you found that a witness indicated that this child had blood on his toilet paper, then indicated that he was touched by someone, what would be your practice as a result of that?
Sustained.
Blood in toilet paper, Mr. Dick, based on your training experience of someone who alleges they've been abused, would you refer them to Children's?
Yes.
Is that what you would have done in 2008?
Objection, Your Honor.
Sustained.
Judge, can we approach him?
Okay.
It may require a little bit more foundation, but I'd like to go and approach how many, I know he said he's had several dozen of sexual assault examinations, but I would ask...
Well, number one, it's beyond the scope of the cross, isn't it?
Way beyond.
If you don't get two bites of the apple, you're limited to redirecting on what was asked on the cross. I don't recall anything about that.
And my one response to that is Mr. Haslam obviously was discussing that there was no physical evidence there, so we would like to respond to say that, well, if this had been there, this would be physical evidence that you would have collected. So it's in response to that line of questions.
We're talking about 2015, not 2008, and they're wanting to ask what would happen.
Well, your question was whether or not if there had been a report, what would he have done? That question is beyond the scope.
Right.
Now, if you want to ask about questions about, how did it affect ability to game, that's fair game. That's covered by scope.
How you want that?
How did the passage of time affect the ability to game? Yeah. You can ask him that. That's within the scope.
So, if we asked a question to the extent that, obviously 7 years have passed.
What he would have done then.
Right.
How does he, when you, he asked about no physical evidence. So you're entitled to establish why there's no physical evidence or attempt to through your questions.
It's been asked and answered.
Well, you brought it up, so I'm going to let him inquire. All right, that question, the objection sustained, we may continue.
Investigators have a couple more questions for you. So it was asked on direct and cross, but after the presentation to the grand jury, you continue to maybe contact individuals involved in the case. That would include defense witness lists, is that true?
Yes.
Okay. Now, we talked a little bit on direct and on cross, it was further, but based on your training experience, can you explain how the passage of time would impact on your ability to collect physical evidence in a case of abuse?
Objection.
Overruled.
It depends a lot on the evidence, but as the passage of time goes, there's more likely that the evidence will disappear. If it's out in the elements, obviously that rain, snow make the elements disappear. If it's inside, cleaning, just over time, that it would diminish the possibility of evidence to be able to be collected.
All right, thank you.
All right, thank you. Let me step down. All right, ladies and gentlemen, we have a little bit of unexpected development based on my prediction. One of the things you're going to learn is that no matter what I predict, kind of like the weather, I'm likely to be wrong when it comes to predicting the scheduling, because trials are fluid and there are things that occur and given the ebb and flow, and we're never quite certain how they're going to come out. We think we know, but we never know until it happens. So we're going to stop today with that witness because any other witnesses would run longer, and I don't want to keep you late on the first day. You've had a long day as it is. So we're going to adjourn at this time and return tomorrow once you're back here at 8:15 with the anticipation we will recommence the proceedings promptly at 8:30. I've been informed that the state believes now that based on the progress of the case at this point, they will finish up with their evidence Thursday morning, and then the defense will proceed with their evidence then. So, there may be that the case will go to you on Thursday afternoon or evening, or it may be Friday morning. That's still in a state of flux, and I'm not going to make any further prediction beyond that at this point. Now, during the evening recess, remember the instructions of the court. You're not to discuss this matter in any way with any person, nor permitted to be discussed in your presence. That includes family members and friends you may come in contact with this evening. You're not permitted to let anyone discuss it with you or to say anything to you about it. You're not to read anything in any type of form, whether it be in the newspaper, in printed newspapers, on the internet, or on any kind of social media. You're not to communicate about this matter on social media in any way, or permit anyone to comment about it on your social media accounts. You're not to attempt to gain any information about anything that you have heard testified to in this case. You're not permitted to, like I said, visit the scene or any other types of efforts to gain information, because the information that you are to decide this case on ultimately will be what you hear from the witness stand and what the exhibits are that are admitted into evidence. All right, so with that, report back here tomorrow at 8:15. And I'll see counsel for just a couple minutes if I'm changed.